Hello and welcome to Legal Updates for CPS and Child Welfare, October 2016. I'm Trish Geary. Local district attorneys, child welfare, and child protective services workers strive every day to protect New York's vulnerable children. Today's training will offer highlights of recent case law impacting your work. Please now join me in welcoming our presenter, Margaret Burt. Margaret is a familiar face to many of you from the child welfare trainings that she's led over the years, and we are delighted to have you back today. Thank you, Margaret. She is a consultant trainer for the Stony Brook University School of Social Welfare, and Margaret has been developing and conducting training on legal issues for both new and experienced child welfare staff for more than 30 years now. During today's training, Margaret's going to provide us with reviews of recent case law on removals and general abuse and neglect issues, general neglect, domestic violence, excessive corporal punishment, parental mental illness, parental substance abuse, physical abuse, sexual abuse, an update on interviewing children in school, Article 10 dispositions and permanency hearings, general termination issues, including severe abuse terminations, abandonment, mental illness and mental retardation, which is now called intellectual disability, permanent neglect, termination dispositions, unwed father's rights, surrenders and adoptions, and Margaret will end today's presentation by discussing several miscellaneous cases. Now, we do invite you to send in your questions for Margaret. You can reach us by phone at area code 518-408-4821, or you can fax your questions using the Questions I Have form on page 55 of the handouts to area code 518-442-6650. And you can also email us. That address is webcast_questions@albany.edu. And one last note before we begin, for the local district attorneys attending today, the University at Buffalo School of Law is offering 3 CLE credit hours for today's training. We've included an instruction sheet for obtaining CLE credit in the handout packet. To qualify, you will need to sign the attorney roster, complete the appropriate evaluation, and fill out the attorney affirmation form. You can find that form on page 53 of the handouts. During the course of this training, you're going to hear Margaret read off CLE codes. When you hear those codes, you will need to write them down on the attorney affirmation form, and you must have these codes written on the form in order to receive CLE credit. Also, just a note, this course has been approved to meet 3 hours of the required CPS in-service. So Margaret, let's get started now, and you're going to begin with some general abuse issues, general abuse and neglect issues, including removals.
Yes. Good afternoon, everyone. I always wish you were here and I could see you all in person. Hope everyone's doing well. Beautiful fall day here in Albany. Can I remind the attorneys in the audience that my cites and the handout are current as of August 29th, which is when I prepared the handout. So there would be a few July and I think later June cases that you might want to check the cites on if you're going to refer to them in any, particularly in any pleadings or in any memo that you're sending to the court. Let's start with removals and general abuse and neglect procedural issues. Our first case, Carrie Ann ZZ from the 3rd Department. The 3rd Department ruled this moot, but as the 3rd Department often does, they had to make a few comments about it before they ruled it moot, and some of them I thought were interesting. This is a teenager who calls the police relative to the neglect that she was being subjected to. She said that her mother's live-in boyfriend, who was a convicted sex offender, was also touching her inappropriately. Mother knew that this had been alleged, but allowed the boyfriend to remain in the home for 4 days after the teenager made the complaint to the police until he was actually arrested. And then mother bailed him out, knowing that the allegations had been made and knowing that the boyfriend had actually admitted to the police that he had touched the teen. The attorney for the child sought an order to remove the child from the home, and that was granted, and the child was able to stay with an aunt. The mother then requested a 1028 hearing, a hearing for the child to be returned, and the court disagreed with the mom and continued the removal. Mother appealed that removal order. But while that appeal was pending, the aunt applied for guardianship of the child. The court combined the guardianship petition with the neglect petition, adjudicated neglect against the mom, and gave legal guardianship to the aunt. So the 3rd Department, after telling this whole tale, then says appeal of the removal is therefore moot. Matter of Deshuna M.H. from the 4th Department. Father in this case had willfully violated an order of protection that he not have any contact with his son, and he was ordered to serve 5 weekends in jail for that violation. The lower court had said that the child's testimony that the father had intentionally contacted him was credited by the court, and that father's alibi witness was not. There had been 2 prior sex abuse reports that had made to DSS that had been unfounded. On appeal, father's lawyer argued that they should have allowed him to cross-examine and in effect impeach or attempt to impeach the child regarding these 2 prior sex abuse reports. And not often cited, but one that attorneys should want to keep note of, 422 of the Social Services Law, Section 5b(i) does allow unfounded reports to be introduced in evidence if they are being introduced by the subject of the unfounded. However, the unfounded reports still have to be relevant to the case. Not only were they not relevant, but I can't imagine what the defense attorney was thinking, because these unfounded prior reports were unfounded because the child had said no abuse occurred. So it wasn't a way to impeach him to indicate that he was not telling the truth. In fact, quite the opposite. And the 4th Department found the rulings of Jefferson County Family Court appropriate. Isaiah from the 2nd Department reversing a family court refusal to hold a full evidentiary hearing when father applied to order that ACS not be able to give a psychotropic drug to the father's child who was in foster care. The appellate court saying this is a major issue, whether or not a child should be given psychotropic medications become a big issue nationally regarding foster children, and that it was a significant issue that this was a proposed medical treatment where there were clearly some objections by the birth parent, and there should have been a full hearing on the issue. Child's liberty and interests were at stake, the child's benefits, not some adverse side effects. All of that should have not been decided on papers, said the appellate division. Trammell A is a lower court decision out of Rochester, Monroe County Family Court, but significant. It's been cited around the state by a number of courts as it relates to our brand new legislation relative to notifying the caretakers, the parents of a sibling who have custody of a sibling or half-sibling. So what happens in Trammell A is that a number, actually a fairly large number, of mothers' birth children had gone into foster care, and Trammell was the latest child as a newborn going into foster care. The older children, most of them had been adopted and had been adopted by several different families. Under the new law, those families should have been notified that a half-sibling to their adopted children was coming into care. At least one of them was still a current and open foster home for the county. That did not happen. Monroe County admitted that they had erred in not doing that, and the adoptive parent of one of the 9-year-old half-siblings stepped forward asking for placement of the infant, the newborn infant, into their home. The Department of Social Services supported moving the child, ruling that the sibs should be together. The home was an open foster home, their fault that they hadn't notified and placed the baby there to begin with. But ultimately, the family court judge refused to move, keeping the newborn child, with a new foster home, ruling that by the time the hearing had finished, that newborn was bonded and connected to this foster home, and that only visitation really could happen at this point. And the court cited the Reg 431.10e, saying that sibling visitation should happen. Zekas B from the 2nd Department, a reversal of a dismissal. Respondent neglected the children, said the 2nd Department, engaged in domestic violence with the mother in their children's presence, and then the father, or the respondent, I'll call him the respondent, didn't say it was the father, the respondent thereafter relocated to the state of Georgia. The lower court has said, well, what's the point of any dispositional order? The aid of the court is not required. This man has moved away. The 2nd Department said, no, relocation is not a valid reason for the court to dismiss, or frankly, everybody would move. The respondent was the biological father of at least one of the children, said the appellate court, and therefore therefore he could return at any time, seek contact at any time, and that the court still should have a dispositional order in place. Chloe W. from the 4th Department, two interesting issues that were reviewed here. One resulted in a reversal of the adjudication and ultimately a remand. In the first issue, there was a question about jurisdiction. The baby, subject baby of this case, had actually been born in Pennsylvania and had lived there for 2 days until the Department of Social Services in Cattaraugus County on the border brought a petition in New York. Appellate court said under the UCCJEA, jurisdiction was appropriate in the New York court because the child and the family had really had a significant connection to New York State. It was just before the child's birth that the mother had gone to Pennsylvania to stay with a relative to help her when the child was born. Mother had maintained her apartment in New York State, had been attending parenting classes there, had mental health counseling in New York State. It would appear as though she intended to return at some point in time to New York State with the baby. Most of her family was there in New York State. And so the appellate court said, yes, it was not inappropriate, although the child had been born and lived for a few days in Pennsylvania, it was not inappropriate to bring the case in New York. The second issue, however, resulted in the Fourth Department reversing the lower court and remanding the matter for a new hearing. There, the court said it was error for the family court judge to have allowed into evidence a report from a forensic psychologist. It was a 3-year-old report, and the psychologist did not testify in person. The report, the appellate court said, is hearsay. It didn't qualify as a business record, and it wasn't harmless because, in fact, the court had based its finding of neglect of the infant significantly on the contents of the report and quoted from it extensively in the decision back to family court for a redo. Maddock E., without discussing any of the facts, so the decision itself is not helpful, but everyone should be aware of this decision. The First Department reversed the lower court's previous finding that a fetus could be a subject of a neglect petition. In the lower court decision, the facts were that the father had engaged in domestic violence against the mother and choked her when she was in her 9th month of pregnancy. There had been 6 prior orders of protection issued telling him to stay away from her. And he'd been arrested just a month earlier for violating those orders of protection. The lower court said in a situation like this, the court was going to accept a petition alleging that the fetus was being neglected when he acted in this way towards mom in her 9th month of pregnancy. But the appellate court said it's moot now because the reversal of the lower court decision was needed so that the lower court decision would not be cited as precedent. I know I talked about this lower court decision when I saw you via tape last year and predicted that perhaps something like this would happen. Just again, so we're clear, the decision doesn't recite the facts. So you'd have to know the connection to realize if anyone cites that lower court decision that a fetus can be the subject of a neglect petition, you'd want to know that that was reversed by this decision. Tyler M., the Fourth Department reversed a Buffalo Erie County Family Court neglect adjudication. Mother had made out-of-court statements to the caseworker and the police officer, but those out-of-court statements are only admissible against her. They're not admissible against the father. And since there was no other proof, the only other proof would have been putting mother on the stand. I'm going to guess perhaps she changed her story, but no other proof other than the out-of-court statements about what would have been the impairment of the child based on the father's behavior, and so the matter had to be dismissed. Thomas B., this is a neglect adjudication out of Ontario County. It was affirmed on appeal, but remitted for a new dispo hearing on a ruling that sort of made the rounds of the family court judges. Lots of people were talking about this one. The mother had relocated to Florida, apparently with some help and assistance from the Department of Social Services. She wished to do that, and wanted to do that. And then after she relocated, she asked the court for permission to make future appearances by telephone. And the family court judge said, no, she should be here in person. This is a significant issue. But the Fourth Department reversed, saying, no, it wasn't unreasonable, especially given her limited financial resources. It wasn't unreasonable for her to appear by telephone instead of requiring that she come back from Florida each time there was a court appearance regarding the disposition. Baby girl Z from the second department reversing a Queens County order that children had been immunized, whether children should be immunized over mother's objection. Very interesting. The attorney for the child brought the motion. These were children that were in foster care. Public Health Law 2164 does allow parents to refuse to have their children be immunized. This is a frequent topic around the various issues in parenting magazines, and it allows a parent to refuse immunizations as long as they have genuine and sincere religious beliefs regarding the child being immunized. The statute puts the burden on the parent to show that that's so by a preponderance of the evidence. Mother claimed that the family court judge was biased and ordered the children to be immunized, and that should be reversed. However, she didn't make that argument for a recusal in the lower court, so she didn't preserve that. However, there must have been something to it, because the second department did reverse the order, saying that the record demonstrate that the judge had a predetermined outcome in mind during the hearing and, quote, took an adversarial stance, aggressively cross-examining the mother, continually interrupting her testimony, mocking her beliefs, and generally demonstrating bias. Not only was there a reversal, but the appellate court said the matter had to be sent to another judge. Brian S. Hey, this is a big deal. This is a pretty serious and significant case that people should take note of. This is a Fourth Department ruling, a case out of Cayuga County. Nothing that Cayuga County DSS did wrong, but still a reversal, and here's why. The majority ruled that the court should have not proceeded given the ineffective assistance of counsel as it related to the child's law guardian. There were 3 teenage children. The allegations concerned mother's neglect. One of the children, I believe this was a daughter, said mother was neglectful and was articulating what was going on, but the other 2 children said that child was lying. So 2 children saying good mommy, 1 child saying bad mommy. The attorney for the child went forward and represented all 3 children, who obviously had very different opinions about what should happen in the case, and cross-examined the DSS witness in a way designed to obtain unfavorable testimony against the mother. In other words, the attorney for the child basically sided with the 1 child who said it was happening and against the 2 children who said it wasn't. Further, the attorney for the child opposed a motion that the mother made to dismiss, undercutting the position of 2 of the clients. Fourth Department said there has no reason for the attorney for the child to substitute judgment. They were teenagers. They all had their own judgment, their own considered judgment, and therefore 2 of the children wanted to go home. The 3rd children didn't, and that didn't rise to a substantial risk of imminent serious harm. The only other reason an attorney for the child can substitute judgment, and therefore it was a violation of the children's rights to not have separate attorneys for children. By the way, in case you're wondering, the argument was being made on appeal by different attorneys for children than the man who had represented them, of the 3 of them in the trial court. There was a dissent. Not often do we see a dissent in the Fourth Department, but 2 judges strongly dissented, saying that the attorney for the child did not err in substituting judgment for the 2 children who said the neglect had not happened, because there was a substantial risk of harm if the AFC had promoted their wishes to return home. The court had no problem concluding that DSS had proven mother's neglect, but reversed anyway, based on the children not receiving effective assistance of counsel in order to rehearing. So DSS is put in the position of, in effect, having to redo the case, having made no error. The only suggestion I can make is that DSS counsel needs to be aggressively making statements to the court if it would appear to counsel that there's a conflict and the attorney for the child is not raising it. Perhaps, for example, if it's obvious to the department based on the petition that 1 child is saying mother's neglectful and 2 are saying no, that child's a liar, that should be simply stated up front in the courtroom, and that the court should be encouraged from the get-go to have separate attorneys for children for the children involved. All right, let's turn our attention to some general or mixed neglect cases. The first one, Jaleesa G. Out of the Bronx. Pattern of domestic violence between the parents, and the court said the child's bedroom was close enough physically to the altercations, both verbal and physical, that would occur so that the child, in effect, could have heard it, been aware of it, and could be at imminent risk for impairment. Mother also had an untreated mental illness. She had a lack of insight into her abilities regarding caring for a young child. 2 years earlier, the father had been found to have sexually abused another older child and to have neglected other children regarding excessive corporal punishment and domestic violence, and he had never engaged in services for those issues. These really show a profound impairment in his parental judgment and were certainly sufficiently proximate in time, 2 years, to form a basis for a derivative regarding this new child. Baby girl A from New York County. This was a summary judgment motion regarding the mother of an infant. The mother and father had been found just 9 months earlier to have neglected 2 older children. So I guess in celebration of that particular decision, a new baby was made. And these older children, their neglect finding had been based on serious, unexplained injuries. And those 2 children were still in foster care when new baby girl was born. At the most recent permanency hearing for those children, the court continued to require visitation, unsupervised visitation, be suspended because mother was seeing father, I guess so, they made another baby, and allowed him to have contact with the baby after being told she couldn't in a protective order. So the court said not only was the prior adjudication very proximate 9 months ago, but clearly mother's behavior since showed she'd not gained insight or self-discipline. Josiah B., a teenage mother who neglected her infant. And sadly, this was a mom who was placed in a residential facility involving a JD proceeding. In that facility, she became pregnant with this child. She was frequently absent from the facility while during her pregnancy. She had untreated psychiatric issues, substance abuse issues, and therefore the newborn baby would be at imminent harm if in her care. Landon U. from the 3rd Department. This is a Cortland County derivative neglect regarding an infant. In 2010, mom and the boyfriend neglected 2 older children of the mother's. The mother had violently shaken her oldest child and then failed to obtain medical treatment. That little boy had a sustained hematoma, extreme cognitive delay, and other complications due to being shook. These older 2 children were still in foster care, and 2 years later, mother had another baby. She had not even progressed to unsupervised visits in those 2 years with the older children. She had a volatile relationship with the father, a physical, verbal abuse. The court referred to them as having dueling orders of protection against each other. However, she continued this dangerous relationship during the time of pregnancy with this newborn baby. Baby was derivatively neglected. The Nashon Desmond C. case, reversal of an ed neglect. Mother and children lived in a shelter in New York City. Mother testified that yes, the children were often late to school, that it took an hour to get from the shelter to the school, and that the shelter had rules forbidding anyone from leaving before 6 a.m. And in fact, she showed that when she was able to be moved to a shelter that was closer to the school, the children's attendance did improve. Beyond that, the tardiness did not apparently result in imminent danger of impairment. One child had satisfactory grades. The other child did have a mix of grades, but also had learning disabilities that could have accounted for that. The first department said this mother did the best she could. She sought tutoring, therapy, other assistance for the children, that in spite of all the obstacles in her life, she'd done the best she could to provide a minimum degree of care for her children. They were not educationally neglected. Justin A., a Madison County mother, a neglect finding against her and her boyfriend, who was the father of the youngest of the 2 children. Mother admitted that the father physically abused her, called her names in front of the children, and also admitted that the father had hit the older child. Mother admitted the children were afraid of him and that the younger child expressed fear about going to school, fearing that his father would kill his mother while he was at school. While the caseworker was in the home one day, the the father appeared and started an argument with the mother in front of the worker. He did tell the worker that he did call the children names, but denied that he did other things, wouldn't accept services. The children both told the caseworker that father was physically abusive to the mother and to them. Mother knew about this. She was neglectful because she was aware of this abuse and continued her relationship with him. It was very appropriate, the appellate division said, to remove the children from the home, and it was not error for an order of protection to have been issued to keep the father away from the mother for a year and to keep the father away from the older boy, the boy that was not his child, until that child was 18 years old. Deshawn W. out of Monroe County, 4 children neglected by mother. 1 child is significant, unexcused absentee rate at school. This did have a detrimental effect on the child's education. Remember, in ed neglect, it's not just the number of days missed. There must be either risk of, imminent risk of, or actual proof of impairment, a detrimental impact on the child. Mother had no excuses for the child's absences. She medically neglected another child because she didn't follow recommended treatments for that child once that child had been discharged from a psychiatric inpatient hospitalization. Other children derivatively neglected based on this behavior, and the lower court gave sole custody of the children to their father. The father, the court said, had a superior right to custody over any non-parent. Mother didn't want those children placed with the father. In other words, mother apparently was arguing that she'd rather have the children be in foster care if they couldn't be with her than be with the father. But the mother did not prove that the father was unfit. That was the Fourth Department's assessment of what she would have had to prove. Wasn't unfit. He had not surrendered, abandoned, or permanently neglected the children in any way. And in extraordinary circumstances requiring the children to remain with a non-parent when a parent was able to take the child. In other words, there should have been extraordinary circumstances against the father in order for the children to be kept in care or away from the father. And best interest was not needed given that there wasn't extraordinary circumstances. Giannis F., a half-brother, sexually abused a child for 4 years. She told her mother on at least 2 occasions that it was happening. Mother failed to protect her. That would be a neglect finding on that mother. Matter of Marquis B., a reversal of a dismissal. This and the next one's 2 cases where parents just won't step up and do what needs to be done, admittedly with a child having some problems. In this case, a father was the subject of a neglect petition. At the end of the department's proof, he brought a prima facie argument, and the Orange County Family Court judge agreed with him. Not proof of neglect, dismissed. On appeal, good job by Orange County, the second department disagreed, reinstated the petition, and remanded it to have a hearing. What had happened was that the child had been living with the grandparents and had been placed in a youth shelter. DSS contacted the father, let him know, this child isn't home with these grandparents anymore, he's in a shelter, we need to work with you. And father said, I'm not taking the child. Child should stay in the shelter, let him learn a lesson. He's a liar. He causes trouble. Father then would not communicate with DSS or the shelter about any long-term plans for the child. Similarly, in Sophia T., the second department also found neglect against a Dutchess County father. This father was made aware that his child was homeless. He would not take the child into his own home and said, I have no responsibility to provide for the child. Also, neglect. Sahara J., parents neglected their children by failing to provide medical care, housing, and by their use of drugs. The middle child had been medically neglected. He had a rash all over his body, and although they went to take the child at one point in time for treatment for the rash, they failed to return even though the rash didn't go away as they were instructed to. In fact, it was not a rash. The child had scabies. The home was dirty, smelled, infested with bed bugs and roaches, large hole in the wall. Very significant, perhaps the first opinion I've seen on this. The father admitted he used something that was referred to as K2, which is a synthetic marijuana. He said he used it every other day. It's kind of interesting. He must schedule himself maybe every other day. ACS called an expert to the stand in order for there to be testimony as to what K2 was and that it was a Schedule 1's controlled substance. And then the 1046 statutory presumption of neglect applied. So no need to show that the use of K2 actually neglected or resulted in impairment. You can use that 1046 statutory presumption that the father would have to refute, and he did not. Derek L., a neglect adjudication against a mom. The child missed 63 of the first 73 days of school. This mom had a long-standing mental illness. She refused to get treatment and was probably the reason that she wasn't sending the child to school. Harper versus the New York State Central Registry. This is an indicated report, a fair hearing case that was appealed to the First Department against a foster parent. It said, interesting sort of factual scenario, foster mother delayed getting medical treatment for a 13-month-old foster child that was in her care. The child apparently fell out of his crib and hit his head. She waited 3 days before she got medical treatment, even though she'd been told as a foster parent, get medical treatment right away. Now, let me be clear. It's not an indicated report that a foster parent didn't obey the rules that an agency might set. So perhaps an agency set a rule, if the child hits his head, you must go to the emergency room. Failing to do that, failing to follow a rule isn't indicated. There has to be an element of neglect, of course, but in this case there was. It didn't matter, said the appellate division, that this child falling might have hit another child, another child that was on the floor, that a young baby falling like that would never have been able to tell a foster mother that they were in pain, and that there would have been injury that might not have been apparent. That is, that it was neglectful, given the child's age, regardless of how the fall actually occurred, not to attend to that fall issue right away. This indicated report, said the foster mother, says maybe I won't be able to foster children in the end. And the First Department said, well, yes, that may be true. Perhaps it should be true, but that's not a defense to getting the matter unfounded. Angelina M., father of 3 of the younger children in this matter, is a person legally responsible for the 2 older children. He had PTSD, was bipolar, and suffered from depression. This resulted in him doing very neglectful things to the children. He punched one of the children in the face as a way of trying to get a tooth loose, get a tooth out of the child's mouth. The children made out-of-court statements that he would choke the mother, threatened to kill her, that they'd seen that he choked one of the children, threatened to kill the children, and had threatened to kill the caseworker. The children's out-of-court statements cross-corroborated each other, and mother and 2 of the children had bruises. Marcus H. out of Chemung County, mother here, 2 teenage sons that were in care. They were in care. There'd been some prior involvement with Child Protective, but they basically were in care because of juvenile delinquency findings. They had burglarized a school, and they were in a group home. A neglect petition was filed against mother relative to what was going on between she and the boys while they were in the group home. First, she argued, I don't have legal custody of these boys. And the Third Department made short shrift of that, saying, you're a parent. You don't have to have legal custody of children to neglect them because you're a parent. And that the neglect was occurring on unsupervised visits where she was testing positive for cocaine and then refusing further testing, knowing that would result in a failure to have unsupervised visitation. She also exposed the children to domestic violence. During these visits, her boyfriend assaulted her in front of the boys. This upset the boys. They were afraid of this man. And even though she knew how they felt about him, she'd bring this boyfriend with her when they came to the group home. She would yell, scream at the boys, use profanity against the boys and the caseworkers. Meetings would have to be ended. The boys would respond to this by mirroring their mother's behavior and acting out toward the staff in the group home. Very interesting case, Chastity OC. ACS brings a neglect petition against a mother as it relates to her teenage daughter, and at the same time brings a petition against the teenage daughter for how she was dealing with her infant child. New York Family Court found neglect on both, but the First Department reversed on the mother of the teen, the grandmother of the infant, saying that she had not been neglectful, that the teen didn't go to school, but mother had formidable obstacles in trying to get that teen to go to school. Language issues, the fact that the teen was a violent and destructive person. At the time of the petition, the mother had not placed the teenage daughter at imminent risk based on education or medical needs. She was doing the best she could. She'd been able to get the child to at least go to family therapy. She'd not been able to get the child to stop using drugs or get into drug treatment, but she believed that the child was not using drugs because of the pregnancy. And in fact, ACS had stopped offering services to the mother regarding this teenage pregnant daughter. But the First Department did agree that the teenager was neglectful of her baby. She had a history of substance abuse. She'd never gotten any treatment. She used drugs during her pregnancy, despite the fact that her mother thought she wasn't. She tested positive for marijuana when the child was born, and she really wasn't addressing the drug issues. The presumption based on her drug use is enough to show the child is neglected. No actual harm needs to be shown, of course, to the child. And the last argument was it appropriate for these two matters to be handled together? And the appellate court said yes, same witnesses, same family. There was no reason the two neglect matters couldn't have been held together as they were. Dante W., father misused alcohol to the extent that he would lose control, injure the child with excessive corporal punishment. The child had bruises. Interesting, I thought, he was ordered in his dispo to have no visitation with the child until a licensed counselor recommended visits, and the child was in agreement with the visits. Don't see that too often. Melanie C., a mother neglected her child by threatening to kill herself and the child in the child's presence. Mother wouldn't take meds, failed to provide medication for the child, who had severe diaper rash. Isabella A., a Cattaraugus County matter. Mother neglected her two children, and she also appealed the court's Article 6 custody order to the respective fathers. Mother neglected her children by alienating them from the respective fathers. She would interfere with visitation. She made false allegations against the fathers, which of course would result in the children having to be examined, probably repeatedly. She told her son to lie about the father and videotaped the child telling these lies. She so confused her daughter about who her father actually was that the daughter wasn't clear who her father was. And this ended up ultimately in some diagnosis regarding adjustment disorders, poor behavior in school. Lower court combined the 10 with the Article 6 petitions that had been brought by the respective fathers, which is appropriate in more recent changes under the non-respondent parent law. The statute clearly says it would be appropriate to combine that in the disposition, temporary 6 only, while the Article 10 was pending, perhaps permanent 6 out of the dispo of the 10, which is what happened here. Out of the court statements of the child regarding the neglect by the mother were admissible in the Article 6 proceedings. That's long been a case law, both in the 3rd Department and the 4th Department, a little bit in the 1st and 2nd, but pretty clear and long-standing case law that an Article 6 matter, a custody matter, child's out-of-court statements regarding neglect can be admitted as though it was a neglect matter. Most of the children's out-of-court statements were corroborated, although some were not. It was harmless. And mother's argument that the attorney for the child should have substituted judgment was no merit. The children were 5 and 6, and they lacked capacity for knowing voluntary and considered judgment, and it was perfectly all right for the attorney for the child to have substituted judgment. In Ashley B., in the 4th Department, a mother was neglectful of her 2 older children, locking them out of the house for days at a time. The children would end up in homeless shelters or live on the streets. They were unsupervised and at imminent risk, of course, and that this behavior derivatively neglected the younger children. Nadia S., child that was severely underweight, and the parents did not comply with the doctor's recommendations to seek on dealing with the weight issue or to get other medical advice. They didn't get any other treatment for this child who was seriously underweight for over 6 months. The father had untreated mental health issues. He was at some point in time committed involuntarily to a hospital. Mother admitted she was fearful of the behavior he had. She would not let him kiss the baby, afraid that he would bite the baby instead. She described father talking to himself for hours at a time, being unstable, angry outbursts, but she would leave the child with this man while she went to work. He used marijuana almost every day, refused to seek treatment for that, and both of them neglected this baby. Anthony B., mother neglected her 2-year-old by failing to provide adequate shelter for him. She was an unemployed mom and lived with her parents, but they disagreed, had a fight about her following the rules in the home. She then left the home with the child and lied about what her mother's behavior was like in order to get an order of protection, which would put her on a higher list to get into a homeless shelter. So she finagled getting into a homeless shelter with lies. She then got kicked out of the shelter for failing to obey the rules there, and for at least a week, she basically rode the subway at night with the child. She said she was staying with a friend but could never provide the name of that friend or an address. When she finally did return to the parents' home with this baby, the baby was pale, hungry, and had not been well cared for. Riley C., a father neglected his child when he deliberately drove his car into the car in which the child was seated. Jaylene A., a child called 911 saying that the father had been shot in the head and the leg. When the police arrived, they found father lying on the floor, a gun near him, bullet holes in the door, shell casings inside and outside the apartment. Father had 30 bags of marijuana on the kitchen table. Father said, "I knew someone was coming to rob me. I put the marijuana in plain view because I wanted them to take the marijuana, not search the apartment, as I hid the children in a back room." Whether that was true or not, the determination was father's behavior neglected his children by putting them at imminent risk. Olivia R., 2 children, 1 and 5. Mother left them alone at night, and one child actually walked out of the house and wandered around outside unsupervised to be found by a neighbor. Neglect. Dawn M. versus the New York State Central Registry. This is a grandma's indicated report. She asked for it to be unfounded. The 4th Department agreed that it should not be unfounded and that her behavior should result in an indicated report. She had 2 grandchildren that lived with her, and they had been sexually abused by her boyfriend, grandma's boyfriend's son. The girls were in therapy, and the therapist had set up a treatment plan saying that the boyfriend should have to live somewhere else. That his presence made the children uncomfortable. He was the father of the boy who had sexually abused them. Grandma did that. Apparently the boyfriend lived somewhere else. However, Grandma did not stop the boyfriend from performing a technique on the girls. He called this technique Cloud 9, and he would run his hands up and down the sides of these girls' bodies. The girls told the grandma that behavior made them uncomfortable, and grandma did nothing to stop it. The fact that the girls made other accusations against this boyfriend and recanted them did not require a different outcome. Jonathan M., mother neglected her child. She left the child in the care of a boyfriend who used excessive corporal punishment. She knew, or she should have known, this was going on, but took no steps. The child was educationally neglected, missed an excessive number of days in schools, and had significant academic delay in all subjects. It wasn't clear whether the child was going to be able to pass that grade. Mother had not been responsive to the school's attempts to seek her involvement. Dior S.J., very interesting here, this case from Queens County. The father had left the child with the mother even though he knew mother was violent and had a history of untreated mental illness. He knew that there was an order of protection that directed the mother to stay away from the child. And after the child went into care, he failed to tell the foster care agency how to get a hold of him and didn't communicate with the agency or the child for several months. That's the part I find very interesting. Well, that happens not infrequently in our cases. But here, ACS was allowed to reopen their proof after filing the neglect petition to add what had happened since the neglect petition had been filed, that he was not communicating with the foster care staff. An interesting and maybe a helpful thing for others to consider. Rakim M., mother had a transient nomadic lifestyle with her children. Neglect, said the 1st Department. She and the children had no home or a shelter. They simply ate junk food, slept in the subway, slept in 24-hour restaurants, or they slept in storage facilities. The daughter had been molested when she lived in one of the storage facilities by a man, a felon, who was living in the storage facility as well. The mother and daughter then said that had not happened, but their recantation was not credible. The mother also didn't make sure the children went to school. She claimed to be homeschooling them, but what she was really doing doing was simply bringing the children to the library during the day and telling them to use the library computers. And of course, there was no approval from any school school board to homeschool. Stephanie R.R., father of 4 children and grandfather of 2 children, all of whom were in the house, was neglectful. One of the children gave extensive oral and written out-of-court statements to a caseworker, saying that this man would hit him, slap him, smack him, that he saw hitting of 2 other children, that he saw his mother being hit. The child said he was slapped in the face and pushed to the garage floor. His tooth was chipped while this respondent laughed. He was fearful that his sisters were hurt and would check on them every morning before he went to school to make sure the children had not been hurt during the night by this man. He described an incident where he saw this man punch his sister twice for no reason. The sister had to wear a cast of some sort due to the injuries that had been inflicted. He also said that he'd watched his mother get hit with objects, watched this man burn his mother's arm with a lighter. The father had been charged with rape and some other incident and was now incarcerated, and the child said the home was happier because he was no longer there hitting people. Mother also testified in court, corroborating these child's out-of-court descriptions. She said, yes, he burned her with a lighter in front of one of her boys, dragged her by the hair in front of all the children, hit her with a baseball bat. She said her children were upset, they were frightened, and that this man also regularly hit, slapped, and pushed the children. Joelle T., mother neglected her child. She left the child at ACS with only the clothing on the child's back. That's it. Don't want to take care of this child anymore. She made no provisions for food, clothing, shelter, medication, or psychiatric care, all of which the child needed, and told the caseworker, I don't want to take care of this child anymore. I don't want to work with you. Just take the child. She had not in the past also given the child medication that the child needed. Demetrius R., neglect where mother has failed to provide the child with an adequate diet. This mother believed in a vegan diet, and that resulted in the child being diagnosed as failure to thrive. She wouldn't let her child be vaccinated, and she wouldn't get appropriate nutritional advice on how to feed the child in an appropriate way. Ricky S., father educationally neglected 15-year-old daughter. This daughter missed 39 days of school out of 74, and it had resulted in the child having problems in school. Interestingly enough, the second department was asked the question about derivative neglect of the sibling. The sibling was not yet of school age. Only the derivative neglect was appealed. The argument being maybe this child was educationally neglected, but it shouldn't be a finding against a child who doesn't yet go to school. The second department did reverse the derivative, but said you can educationally neglect a child who doesn't yet have to go to school in a derivative way, but not in this case, because the 15-year-old was part of the problem. The 15-year-old resisted going to school. The respondent did try to get the child to go to school. There wasn't sufficient evidence of such an impairment of parental judgment as to warrant derivative regarding the child who is not yet of school age. I wonder if the defense attorney wished he'd also appealed the 15-year-old's ed neglect, hearing that kind of language. Domestic violence as neglect. Illyria E., a Bronx child making out-of-court statements that her father was violent to her mother. The mother supported that. The caseworker and mother's medical records supported that. Father said, no, it only happened once. But the appellate court said once is enough if your judgment was strongly impaired. And in any event, we don't believe you. We believe it did happen more than once. And on the day in question, you clearly pushed the mother. There had been an order of protection that you weren't supposed to be there after a subsequent incident. Serenity H., child had been exposed to domestic violence. The mother denied there being DV in the home. She refused to accept services. She refused to enforce an order of protection that had been issued, saying that the father had to stay away. And the child was able to talk about what she'd seen of the fights between the mother and the father, supported by the caseworker and the police officer who responded. The police officer spoke about the impact on the child by saying the child looked like she'd been crying and was breathing very, very quickly, rapidly. Mother testified that she complained to the police in the past, and she did admit that the child had been present when there had been arguments. Ruben G., a reversal of the Brooklyn dismissal of an Article 10 petition at the close of the case. The appellate court said no, lower court was wrong. A prima facie case was proven, sent it back for a new hearing. The proof that was offered was that mother was admitted to emergency room, that she told the worker there that the children had seen the man physically abuse her, and the caseworkers testified, we had in the past set up a reasonable safety plan, and she didn't follow it, and she allowed this man to continue to live with her and the children even after that. Clarence S., Bronx, a father neglected the children. He committed an act of domestic violence against the mother in the children's presence. One of the older children described the fight and said that the respondent had hit the child in the head with an iron when this teen had tried to intervene to save his mother from being hit. The child did have a wound on the forehead. It was bandaged. It's the wound he said that had been inflicted when he'd been hit with an iron. Another child told the worker the same information when interviewed separately, and the children's out-of-court statements about this fighting were cross-corroborated by each other, corroborated by the injury on the forehead, and the police report that domestic violence had in fact been reported. A lower court denied the respondent's request for an adjournment, who said, I need to go to a family function in North Carolina. The court said, I don't think so. Moises, I think, if I'm mispronouncing that wrong, I apologize, father stabbed mother multiple times in the home while the children were there but in another room. The child, at least one child, heard the mother screaming for help. The stabbing resulted in a severe injury. The mother was in the hospital for a month. Although this may have been the only act of violence that was proven, it certainly showed father's strongly impaired judgment, and the children were in imminent danger of being harmed. Navia, children were exposed to repeated incidents of domestic violence. The home was only one room. Therefore, the two young children were very physically close to the fighting that was going on. The father made statements that were admissible as excited utterances. A good thing to remember from law school. Statements were corroborated by the parents' medical records. The father had a stab wound, and the mother had bruises and bite marks. Cheyenne O.O., two of the children made out-of-court statements that their parents were yelling and hitting each other. The 8-year-old girl said that this made her sad and that they were now happy, a happy family, because the father had left. The 14-year-old said he would try to keep his younger siblings from seeing the violence, but that the children did in fact see the parental fights, and the boy talked of being frightened by the violence. He talked about a time where he had to take his shirt off to try to stop the mother's blood flow. She'd been hit so hard in her nose. The mother testified that she was a frequent victim of the father's violence and that all the children had been exposed to violence. She also said that the children were verbally denigrated by the father, that they were afraid of him, that they wouldn't respond when he would say abusive things to them, and that he hit them. And he would particularly hit that 14-year-old boy, the boy who had tried to intervene to help her. I am going to, for the attorneys in the room, read you the first code for CLE. Please make sure that you're writing it down. It is L like Larry, S like Sam, the number 1, 0, 1, the number 6, S like Sam, B like Bobby. LS 101 6SB. Please make sure to write that down. All right, we're going to look at Travern H., stepfather, committing acts of domestic violence on mother in front of the children. Mother not preventing the children from seeing it, being impacted by it. The children said they saw the stepfather hit the mother. This out-of-court statement was corroborated by the caseworkers. Both of these children were autistic. The daughter said, it makes me cry when stepfather hits the mother. The mother told the caseworker the son did not like the arguing. Police had been called on multiple occasions, but the mother would not leave the stepfather. She knew that there had been another neglect matter pending against the stepfather for his violence against his former girlfriend, and that had occurred in front of his daughter. Mother neglected special needs children also by leaving them alone on at least 2 occasions, knowing that these children had very difficult time communicating. As I said, they were both autistic, and one of them suffered from seizures. A couple of cases to look at in the excessive corporal punishment area. Jedozak, perhaps. This child made out-of-court statements that her mother instigated an altercation and then hit her in the eye with a telephone. Child's out-of-court statements were corroborated by injuries the caseworker saw and the mother's own testimony. Dawn M., excessive corporal punishment of a Broome County by a Broome County father regarding his children. The child that was the oldest of his four was 9, had facial bruising, large marks that were visible in photographs a day after the incident. The caseworker and the doctor who saw the child believed the marks were consistent with an adult handprint. The father had slapped the child in the face when he became angry, that she told her mother, "He won't help me with my homework." 2 other sisters disclosed they had seen the father hit the older sister, and the children's out-of-court statements corroborated each other. Jaden R., a mother used excessive corporal punishment on her son. The child said that the mother had a history of hitting him with a belt that caused bruises. The statements were corroborated by the medical records, photographs of the bruises, the caseworker's observations of the bruises. Mother said, "Yeah, I hit him with a belt, but it was only once, and the child bruises easily." The child said no. The multiple incidents of being beaten, and even if there was only one incident, it's enough. Mother also knew her boyfriend used excessive corporal punishment on the same child and didn't protect him from that. Natasha O., a dismissal of neglect allegations was reversed by the First Department. The First Department said, yes, there was preponderance of evidence that this respondent had deliberately burned a child, just 3 years old, as punishment for the child having taken a toy from another child. The child had a round burn on her inner arm, and when asked, the little girl said, "Daddy burned me with a cigarette," when she was asked how she got the boo-boo. With another caseworker, she used a circular motion to show that something had been pressed against her arm and said Papi was the person who did it. Respondent said, no, it was an accident. I had a lit cigarette. She came in contact by accident. The appellate court said that inherently improbable the way he described it. He also said that the burn didn't appear until the next day. He also said, gave varying accounts of where the burn was, and said that the mark was only about the size of a mosquito bite, and that the photo that had been put in evidence was not an accurate photo. Even if this was only one incident, the appellate division said the Bronx County Family Court was wrong to say that it wasn't neglect. Intentionally burning a child demonstrates a strongly impaired parental judgment. Derivative on the other children as well. Dylan V., excessive corporal punishment of a 14-year-old stepson and a 12-year-old stepdaughter. Both children said that stepfather hit them on an ongoing basis. They corroborated each other. Stepfather punched them, hit them with an open hand, a closed fist. The boy described an incident where the stepfather choked him, restrained him. The children's grandparents had been living in the home for about a month, and they also corroborated the statements, saying that they watched the stepfather use excessive corporal punishment on both children more than once. The children and the mother left the state before the dispositional hearing, so the lower court issued an order of protection against the stepfather. On appeal, the stepfather said, why should there be any kind of a ruling? Our relationship has ended. She's left town. Third Department didn't think that that was sufficient. Joseph R., a boy testified in court that his mother used excessive corporal punishment on him on a regular basis. Used a belt to strike him, made him kneel on rice, which I am told is quite painful. Made him kneel on rice while naked. She scratched the child deep enough to cause him to bleed, kneed him in the groin. And she also used excessive corporal punishment on her daughter. The court obviously struggled with placing the child with the father. The father had a very crowded apartment, but essentially the court said crowded apartment with father is better than this boy's situation with his mother, and had the child remain with the father. And let's talk about parental mental illness. Let's handle one case and then we'll take a break. Matter of Essence S. This mother neglected her 2 young children. They were her 4th and 5th children. She had a bipolar disorder, not otherwise specified, post-traumatic stress disorder, borderline personality disorder, and she used marijuana. 3 of her older children had been removed from her care. 2 of them were already adopted. The other was in the custody of their father. A petition was brought regarding the 4th child, and while that petition was pending, she gave birth to a 5th child. So these 2 children were now the subject of this petition. She behaved bizarrely at the hospital during the birth of these other children. She was clearly in need of mental health services. The mother when pregnant with the second child, had had a mental health evaluation regarding the first child and confirmed all the diagnosis and indicated the child should not be returned. She had also violated the temporary order and had unsupervised access to that older first child. Why don't we take a little bit of a break?
I think that's a good idea, Margaret. You've given us a lot of great information on these important cases, and we really appreciate that. But let's take a quick break right now. Please do keep sending your questions for Margaret. Our contact information will be on screen during the break. When we come back, Margaret's going to continue her discussion of highlights and changes to relevant case law. We will see you in just a few minutes. Welcome back. I will turn the program back over to Margaret in just a moment, but first I do want to let you know that if we have some time after Margaret's presentation is wrapped up, she will address some of the questions that you have sent in today. Thank you for those, by the way. If we don't have time to get to those, though, Margaret will actually be reviewing all of your questions, since she does take the time to provide feedback. Thank you, Margaret. So please be sure to include an email address or a phone number with your questions so she can follow up with you. So, Margaret, let's now get continuing on your presentation.
And you'll remember that we are in the middle of parental mental illness as neglect, sad cases. And we're going to pick up with Enrique S. from the First Department. This father put his children at imminent risk due to his failure to get mental health treatment. He had bipolar disease. He was aggressive and violent, and in particular toward the children's mother. And Justine N. from the First Department. Mother had mental health issues. She engaged in bizarre behaviors, paranoid ideation. She was functionally impaired to the point that she really might have a psychotic disorder. She forced her 15-year-old out of the home overnight. The youngest child had nightmares, feared being sent home, and the lower court actually ended visitation for that child. Elisana, PP, mother had her parental rights terminated to children on mental illness grounds, but then 1 year later she had another baby. That baby was the subject of this neglect petition. And the Third Department agreed that that child was derivatively neglected and issued a 1039B order that no efforts needed to be made towards reunification based on the prior terminations of parental rights. So, of course, that child couldn't be the subject of a termination of parental rights until the child had been in care for 1 year, but there would not need to be any proof, either if there was a mental illness TPR by statute or permanent neglect by this ruling. There would be no proof needed of diligent efforts towards reunification. Mother had a lengthy history of mental illness. She'd not been getting treatment. The older children had been in care because of her mental health problems. She was bipolar, suicidal, aggressive, angry, had adjustment personality disorders. She'd put the older children in lots of unsafe situations, left them unattended in a bathtub, left them unattended in a room where they broke a window and were injured. The older children would spread feces on the wall, floors, on her toys, because she would leave them alone and not have them supervised. She left them in a room where there was an open door to an unsecured balcony. In the prior TPRs, of course, there had been expert opinion that she wasn't capable of providing safe care for those children for the foreseeable future, and she had not received any treatment, mental health treatment, between the TPR and the birth of this new baby. She didn't believe she needed treatment. She thought vitamin shots would be sufficient. Her demeanor in court, don't forget to comment on that. If there's demeanor there, the record should reflect that the demeanor, sadly, demonstrated that her mental health issues had not been addressed. Michael P., mother's mental health issues resulted in neglect. She had paranoid delusions. She believed that her neighbors were harassing her, talking about her. She believed that she was friends with an international pop star. Child's teeth were badly decayed. Mother didn't get dental treatment for him. Her untreated mental health issues basically meant that she was unable to provide basic supervision for this child, and the child was at imminent risk. An expert testimony in a mental illness neglect proceeding is not needed. A simple proof of the parent's inability to care for the child is sufficient. Kaimia M., a neglect dismissal reversed on appeal. Second Department said to Queens County Family Court, no, this is a case of neglect. The mother's mental illness poses an imminent danger. The child was very young, only 3 months old. Mother lived in a homeless shelter with the child. The mother had paranoia and delusions. She would call the police repeatedly, saying that there were people outside the shelter who were threatening her and the baby. There were no people doing it. These were delusions. They would become vivid and realistic delusions as she talked about them. She would get more more and more upset. One night, the child was very cold and was seen dressed only in a diaper, shivering near an open window, while the mother was obsessing about these delusions. Would not follow up on any mental health evaluations. Thomas B., mother engaged in bizarre and paranoid behavior toward the older child. This was done in the presence of the younger child. There's no requirement that DSS provide actual proof about a particular diagnosis that isn't necessary, only that the behavior is happening. Zoe A., mentally ill mother, exhibited bizarre behavior. She handled a newborn baby roughly, didn't support the child's neck and head, left the baby unattended, didn't clean the baby, didn't change the baby. Sadly, she had severe mental illness with symptoms and would not acknowledge her problems. Let's look at some case law on parental substance abuse. Dayan J.L., the caseworker testified that on at least 2 occasions, she observed father reeking of alcohol. The occasions were quite significant. One was during a supervised visit with a child, and once one was at a court appearance. The father was advised that he should have a substance abuse evaluation if he wanted to have the child in his care, but he refused that. Again, actual impairment of the child does not need to be proven where there is prima facie case under 1046A III that a person is repeatedly misusing alcohol to that extent. J.L.E. R.H., reversal of family court's dismissal of an Article 10. The appellate division said, no, this is neglect of a 3-year-old. The police executed a search warrant on father's apartment. Inside the apartment, they find multiple packages of crack cocaine, heroin, and a large quantity of marijuana. Let's remember that this child was 3 years old. They were all within reach of this 3-year-old. The mother knew or should have known about the drugs in the house, so she too was neglectful. Julianne B., mother and stepfather, were found to have neglected the mother's teenage daughter. Only the stepfather appealed. He argued that there was not neglect, but the third department agreed that there was. DSS was not required to show imminent impact on the child where there was proof of the respondent repeatedly misusing drugs. Here the proof was that they smoked marijuana every day, multiple times a day, and in front of this teenager. Their judgment was so impaired that all kinds of things were happening in the home. They allowed the supplier of the marijuana to come in and out of the house, often with the child present. They sold marijuana all out of the home, including to people who went to school with the child. Sometimes they actually had the child involved in the drug sales. There was what the court called a drug-infused atmosphere in the home. I don't know if they were referring to the smoke or what, but a drug-infused atmosphere. The child had actually gone to get professional help to deal with the situation of the parents selling marijuana out of the home. Neither respondent testified, and they didn't offer any evidence that they were involved in any kind of rehab program. Not only was there a statutory presumption based on their use, but their sale of marijuana out of the home also put the child at imminent danger. Emmett R.R., the father neglected his child. He drove them to school while he was impaired by alcohol. A police officer had pulled him over, seeing the father driving erratically, saw him swerve into the path of a dump truck. The officer saw the daughter in the car. There was an odor of alcohol in the vehicle. The father admitted he'd had 3 or 4 beers, but that was the night before, but then failed 4 sobriety tests in the field. The officer testified that this man was impaired by alcohol. He got 4 traffic tickets for various infractions, although he was not actually arrested for any alcohol-related charges. Both the daughter and the son, who had been dropped off before the police officer pulled the car over, told the caseworker that their father had frightened them by his driving that morning, and the father told the caseworker he had been drinking beer in the early morning hours. Vida C., Kings County dismissed a neglect petition, and again we see another example of the appellate division saying no, it's neglect, the family court judge was wrong. The lower court dismissed the case at the end of the direct proof, apparently in response to arguments that there was no proof of harm to the children. The second department restored the petition, remanded for a new hearing, saying the allegations were that parents abused alcohol to the point of intoxication, and under 1046A, 3 little i's, something that for whatever reason, a number of family court judges don't want to hear, but it's right there in the statute. If we can prove that the parent is repeatedly intoxicated, there need not be proof of any impact on the children. Here, the caseworker not only observed the parents to be intoxicated, but the parents were repeatedly admitted to a hospital for their level of intoxication. They both had been determined to be alcoholics, had not gotten any treatment, and the 14-year-old child said, "My parents drink every day, they're regularly intoxicated, and I want my parents to get some help." Prima facie neglect, says the second department. Timothy B., father chronically misused alcohol to the point that he would be intoxicated, disoriented, incompetent, irrational. That's right out of the statute of 1046 AIII. We got a smart cookie attorney there in Livingston County. The father was driving while intoxicated at 2 in the afternoon on a weekday. He was involved in an accident. He was intoxicated to the point that he couldn't perform field sobriety tests. They had to actually stop him from falling over or walking into traffic. The children made statements that the father was mean and aggressive when he would be drinking, and that he pushed one of the children to the ground. The oldest child would have to be preparing the meals because the parents would be too intoxicated to do so. This oldest child also held down a job, and he would have to go make arrangements for the youngest child to go to a friend's house because the parents would be too intoxicated to take care of that child while the older child went to work. The youngest child would hide under furniture while the parents were drinking and fighting. Father claimed they only drank when the children were asleep. But the evidence showed that the children were well aware of the drinking and had seen their parents intoxicated on many occasions. Madison M., a prior neglect adjudication to another child based on the use of drugs. Mother then gave birth to this child and would not allow the drug testing for herself or an infant, even though at the hospital it appeared as though mother was under the influence. When the baby was only 18 days old, mother took the baby to crack houses. Within 9 months of the birth, the mother was arrested for using drugs. She was observed by a detective leaving a crack house with crack cocaine and a crack pipe. When she saw the detective, she didn't drop the crack cocaine or the crack pipe, but she did drop the baby in the crack house lobby. All of this triggers the presumption of neglect of the baby under 1046A III. Let's turn to abuse, physical and sexual abuse. Sadly, a lot of cases here to look at. Matter of Richard S. DSS established a prima facie case of abuse, but here the second department found that the respondent mother, father, and grandmother presented sufficient proof to rebut the abuse. Basically, they put on experts to say that the child's injuries, which were severe, perforated bowel, fractures to the left leg, fractures to the left arm, bruises, that the defense experts provided proof that they may not have been intentionally inflicted by the respondents. However, there was proof that the parents did not medically attend to the child, that they were neglectful, that they didn't seek medical attention for the child's injuries. Although the petitions had not originally alleged medical neglect, only the physical abuse. But in the arguments, in the closing arguments, both DSS and the attorney for the child argued that the court should make a medical neglect finding, and then the court gave all the parties 60 days to respond to that. Respondents didn't raise any arguments that they hadn't been given ample time to respond, and therefore the court, having conformed the pleadings to the proof about medical neglect, was not preserved. Mother was neglectful based on not only that failure to get medical attention for the severely ill child, but also on her abuse of prescription medications. There was a complaint on the appeal that the DSS put information in their appellate brief that had not been in the record, but the court said, no, it's all right. It was the same information that was in the attorney for the child's brief and labeled as an update, and so it was properly provided. I'm not sure that really makes a whole lot of sense, but we are all aware that many times the appellate divisions allow all kinds of updated information to come out in oral argument because the court's interested, I guess, in what has happened since the case has been heard. Ashlyn Q. This is a Clinton County matter. Mom and the fiance are physically abusive and neglectful of her 6-month-old daughter. That the fiance is derivatively abused, neglected the child, neglected his son from a prior relationship. This little baby had a fracture of her left arm when in the care of the mother and the fiance. taken to the emergency room in the middle of the night. The board-certified pediatrician said mother offers no explanation for this broken arm, and further the child was incapable of inflicting that kind of an injury on herself, and that the injury was not an accidental type of injury. The doctor thought that the child's arm had been broken sometime between 1 and 4 a.m. that day, and during that period of time, the only caretakers were the mother and the fiancé. The fiancé's mother testified that her son had told her some 3 months earlier that he had shook and thrown the baby, who was then 3 months old, when the baby wouldn't stop crying. The caseworker testified the fiancé had said that he'd shaken the baby, and the mother said she knew the fiancé had shaken the baby, but that had been fixed by the family. The family had agreed that the fiancé was never going to care for the baby alone after that. He did acknowledge, the fiancé, that he'd had several violent outbursts against the son's mother, his own mother. His own mother said she was afraid of him. The only explanation for the broken arm that could be offered was that they thought maybe grandma had done it. And the court found the fiancé's mother's denial of that to be quite credible. The fiancé was not entitled to any visitation with the child. He's not the child's father. And the mother should be limited to supervised visitation. Kayleen Ash affirmed severe physical abuse findings regarding a mother, but modified the derivative severe abuse findings as they related to the children that were not biological. So the medical testimony had established that one of the mother's children had a fractured leg and fractured vertebra that would have only occurred because of abuse, and actually ended up requiring spinal surgery on that child. Mother gave implausible, unreasonable explanations. Mother and the two other bio children, therefore, it was a severe abuse on the child who was injured, derivative severe abuse on the bio children. But the first department said, no, not as to the children that aren't his. They're not this mother's bio children, and so that can only be abuse, not derivative. We fixed that now because we have a new statute that went into effect in February that courts can now make findings of severe abuse regarding the non-bio child, and of course that's very helpful to us in situations where the person may have other bio children that have not been harmed, but we wish to protect those bio children. Naheem E., mother's 7-week-old infant, multiple fractures, ribs, left leg, skull, retinal hemorrhaging in both eyes. These injuries would be the result of non-accidental trauma. Parents were the only caretakers. Mother failed to get medical treatment in a prompt manner. She could see the child was in pain. The child was twitching. There was no requirement that ACS had to prove which of the caretakers did it, the mother or the father, or even if they both did it. Mother's attempt to blame her 3-year-old for having inflicting the injuries was not sufficient rebuttal. Mother also used marijuana, and that neglected the children. She told the caseworkers she smoked marijuana only on the weekends and holidays, and admitted in her own testimony that she did smoke marijuana in the family home, but only after the children were asleep. Those are enough to establish the presumption that the children were neglected due to the marijuana use as well. Nabel C., mother and father and a grandmother, abused the 7-week-old infant. This child had an overdose of morphine, heroin, and codeine. This is not the first time that we've seen these cases. It's not really clear, but it appears in some of these cases that perhaps parents are using drugs to quiet the child, make the child go to sleep, and who knows how much morphine, heroin, and codeine are appropriate for a 7-week-old infant other than none, and these children become horribly ill and sometimes die. The baby lived with the mother and the grandmother, and the father visited frequently. The 3 of them were responsible during those days when the child would have been overdosed. The forensic toxicologist said it's not possible to determine exactly when the opiates would have been given to the child. And the first department said then all 3 of them are to be found responsible. None of them could rebut any evidence as to how the child had been exposed to the drugs. None of them could offer any explanation as to how the child could have ingested the drugs. Samana R., respondent was a person legally responsible, who was the primary caretaker of the subject children. Mother would go to work. This would be the boyfriend that would take care of the children. He told the mother one day when she returned home from work, 3-year-old's not feeling well. The mother later found the child unresponsive brought the toddler to the hospital in the early morning hours, and the child had bruises all over his body, blunt force trauma to his abdomen, his bowel. The child went into cardiac arrest and died at the hospital. The ME testified that these injuries were not accidental. They would have occurred just hours earlier in the day, which is when the boyfriend would have been taking care of the child, and he could offer no reasonable explanation. Clearly a severe abuse case. Maybe not brought as such because he was not the father. However, under our new law, it should be brought as a severe abuse case. George S., a man severely abused a 3-year-old girl. She died. Blow to the abdomen that ripped her bowel. The child had abrasions on her body that indicated ongoing child abuse. He was not the child's father, but he was the primary caretaker, and there was one child in the home that was his own child. No evidence offered. Again, that's a severe abuse case, appropriate, and derivative severe abuse, appropriate on the other, the sibling to that child as well as his own child. And then a sad case, of a child that we know much about. The Marcella P. 2010 murder of a 4-year-old little girl. ACS brought abuse petitions against the child's mother and grandmother, who had been taking care of this severely abused child, and her 2 brothers. The child had died because of acute drug poisoning, blunt impact trauma, malnutrition, dehydration. That child essentially was tortured. The father of the child was charged with neglect. The grandmother was criminally convicted of manslaughter and other charges in conjunction with the child's death, and the family court adjudicated the grandma to have abused the child and derivatively abused the brothers with summary judgment. It was nothing to say after she'd been convicted. The father was found, after fact-finding, to have neglected the deceased child. He was in and out of the house. He knew what was happening to that child, and he also neglected the children because he misused marijuana. The brothers went into foster care. Father only got supervised visitation with them. Both the father and the grandmother appealed. Remember, grandmother had been convicted, criminally convicted of murdering this child. Grandmother argued on appeal that she didn't get effective assistance of counsel in her family court action because there was no opposition to the summary judgment motion to find her severely abusive. The Second Department said, there's no argument your attorney could have made that would have had any chance of success given your criminal conviction. Why someone would appeal that? The father failed to exercise minimal care of the deceased child. He didn't take action. He knew what was going on, and he derivatively neglected the surviving brothers. Mason F. is a cross appeals out of Ulster County. Good job, very good job Ulster County did on this tragic case, and I'm sure the defense attorney is not happy with having made the decisions that attorney made. In this case, the mother and the boyfriend were alleged to have severely abused her child. Her child died of blunt force trauma. There were also derivative petitions regarding a younger child who did not die. The lower court made a finding of neglect and abuse against the mother, but would not make a finding of severe abuse, saying the mother really didn't display utter disregard for the child's life. Apparently, the mother argued that she had given the child coconut water. The mother appealed the neglect and abuse findings. Oh, what a mistake. Because in appealing the neglect and abuse findings, DSS said, well, all right, we'll cross-appeal the dismissal of the severe abuse and cross-appeal the derivative severe abuse for the younger child. The mother, by the way, the boyfriend had been criminally convicted of murdering this child. The mother did act with utter disregard, said the appellate division. She allowed this boyfriend to move into her home after she knew him for 2 weeks. She knew he was a person that went out at night to purchase drugs, but she let him watch her children. She saw abnormal bruising on her child as soon as the boyfriend moved in, saw that the child was walking oddly, described it as the child walking with a stick up his ass the day before the death of the child, knew the child wasn't eating normally, and posted on her social media account that her child was horribly sick. She was aware that there were bruises on the child's eye, stomach, groin, on the back, and that he had vomited black material, that he'd passed a blood clot in his bowel movement. Witness testified the child looked like he'd been hit by a bus 2 weeks before his death. The child was pale, black eyes, cut-lipped, bruises on his arms and legs. The ME said there were over 60 bruises in various stages of healing, a fractured rib, a severed pancreas. Mother was reckless. She disregarded the safety and the well-being of her child by accepting claims from the boyfriend that all of these injuries had been accidental and that the child simply bruised easily. She failed to get medical treatment, knowing her child had extensive bruising, seeing the child have the black vomit, and the blood clot in the bowel movement did not move her to bring the child to a doctor. She was advised by several people this child needs medical condition and didn't do so, and she said why, that she was afraid CPS would be called. Lastly, that younger child had a severe ear infection, inflamed nipples, and a hickey below the right nipple. And the appellate court said, something's happening with this child. This child is clearly traumatized in some way, perhaps even being sexually abused. So the third department had no trouble making a severe abuse finding. And as I said, I'm sure the defense attorney was questioning that judgment of appealing the neglect and abuse case. We have a larger number of sexual abuse cases than usual, most of which are pretty horrible. And I don't know if that means we're seeing more sex abuse cases, more have gone to trial, more have been appealed, but a larger number than usual. Michael B., a mother abused her 7-year-old, failing to protect him from being sexually abused by her 13-year-old brother. She didn't also properly take care of the older brother, the person who was perpetrating the sexual abuse. She should have gotten him help, supervision, guardianship. In the summer of 2012, the boys were making statements about the sexual abuse that was going on between them, and only at that time did she have the older boy move out and seek treatment for him. Shania, Queen's case, a father sexually abused his daughter. This 9-year-old gave consistent, detailed, out-of-court statements to several people in which she described sexual abuse that had been happening since she was 6 years old. This out-of-court statements were corroborated by the testimony of an adult sister who said the same thing had happened to her when she lived in the home. Dorlis B., an adjudication of sexual abuse by the father. The eldest child gave detailed out-of-court statements corroborated by an expert that the child was suffering from depression, had attempted suicide. This child's behavior was consistent and validated her claims of sexual abuse. Behavior was not otherwise explained. Child's guidance counselor talked about the child's behavior and about the child's consistent statements to her of sexual abuse. Irania, a derivative neglect, abuse, and severe abuse finding regarding a father's 8th child, number 8. 2010, the father had been adjudicated to have neglected, abused, and severely abused his then 6 children and a child of his former wife. This involved repeated sexual intercourse with the ex-wife's child beginning when that child was 7. 2 years later, in 2012, he had a 7th child, and the court determined that he had derivatively neglected, abused, and severely abused that child. The appeal concerning those findings as to this appeal was about the 8th child, who was born in 2013. At the time of the petition of this child, he had not done any of the recommended treatment for counseling. He continued to deny that he had sexually abused the former wife's child. The court said these prior determinations are sufficiently proximate in time. That would be 5 years. 5 years earlier had been the original findings. Sufficiently proximate, says the appellate division. There's no bright line temporal rule, but the court will not consider for the court to consider the prior determinations. But the 2008 acts of sexual abuse were close enough, and with his failure to get any treatment, to lead to the conclusion that these conditions continued. He had not completed his treatment. He was still not being allowed 5 years later to have unsupervised visitation with his younger 6 children. April WW, kind of an interesting battle of the experts. I'm going to summarize it, but well worth reading this decision. It's a sex abuse case where ultimately the third department decided that the Delaware County Family Court judge had to be reversed, that the expert provided by DSS just did not match the expert provided by defense counsel. What we have here was a 3-year-old girl. The 3-year-old girl was living with her mother and an older brother and the maternal grandmother. The maternal grandmother's boyfriend was a level 3 sex offender. The child made no disclosures, and I think that's significant in the case. The child did not say anything was happening, but the mother brought the child to an emergency room asking for an examination, saying DSS is falsely accusing this boyfriend of sexually abusing the child. So the mother brings the child to the emergency room for proof that the child child is not being sexually abused. Now the child is examined at the emergency room by a nurse and a pediatrician. They testify for DSS, and they say there's evidence the child's been sexually abused. The mother brings in a pediatrician who examines the records, who says, no, there is no evidence of sexual abuse. Family court judge says, I credit the DSS experts, I make a finding. The appellate court says no. DSS experts were no match for the expert that had been brought in by the defense. The DSS expert, who was the child's treating pediatrician, had really very little experience in dealing with sexual assault of a child. She even said she had essentially only done one sexual assault examination, and that had been when she had been a resident some 15 years earlier. She admitted that she had to call a colleague to ask for details about how to even examine a child this young, how to position and examine the child this young in order to determine whether there had been sexual abuse. The emergency room nurse was more experienced. She had 17 years of experience as an emergency room nurse, and she had started the training, the same training, the sexual assault nurse examiner training, but she had not finished it. And she had only performed 3 examinations for sexual assault on girls under 5 years of age. In contrast, the defense brought in a pediatrician who was board certified general and child abuse pediatrics. He took child abuse electives in medical school. He worked in a hospital child advocacy center. He was trained in the performance of pediatric sexual assault examinations. He had done sexual assault examinations on 1,400 children. 350 of them were girls under the age of 5. He'd been qualified as an expert and had testified in over 60 cases. They did not name him, but I assume his name is well known. Testified in over 60 cases in the family and the criminal courts. He testified that in every single case he had testified for the Department of Social Services, and that this was the first time he had ever testified in court on behalf of a parent saying that sexual abuse had not occurred. He said that he did not examine the child, but that his review of the records made him confident that he could draw conclusions that there were no physical findings of sexual abuse. In essence, the appellate court said the lower court should have examined the experts more closely and relied too heavily on the fact that the defense expert had not actually seen the child. Remember, again, this child had not complained of being sexually abused. The appellate court said there's no credible medical evidence the child had been abused. The child had never complained about being abused, and there was no evidence that the child was exhibiting the behaviors known of sexually abused children. And therefore, not only was there no sexual abuse, but there was no neglect of the child, because not protecting the child from sexual abuse can't be neglect if there wasn't sexual abuse to protect the child from. However, the court said that children were neglected. There had been numerous instances of inadequate supervision. Mother had refused DSS's assistance. She allowed sex offenders and questionable people in the children, despite specific instructions from caseworkers that certain people were to be kept away from the children. She knew the grandmother's boyfriend was an adjudicated sex offender, although she claimed, I never let him alone with the children. She didn't accept help to find housings away from that situation. And the little girl had poor hygiene, multiple infections in the diaper area due to lack of cleanliness, a failure to provide medication. The child would wheeze due to secondhand smoke. Mother directed the boy to go to a home where she knew there was a vicious dog. The child got bitten by the dog. So the appellate court was not going to let the mother off, saying there is neglect. But the appellate court said we have to look at a new dispo order, because while this case was on appeal, the family court judge ordered DSS to begin termination proceedings because mother had refused to acknowledge the sexual abuse. And the third department said you can't file a TPR while you have a situation here where she's not admitting something that in effect you didn't prove happened. And they made one more comment that I find a little difficult. The third department commented that they thought it was contradictory to order a filing of a TPR at the same time that the goal of reunification was happening. Yeah, that is concurrent planning. That's actually good practice and is really what happens mostly around the state. We'll see if maybe there's another issue that might go up to the third department around that. Alejandra B., sexual abuse of a 10-year-old. This child testified. She was permitted to testify via closed-circuit television because the lower court properly balanced the respondent's due process rights with the child's well-being and saying the child would suffer and wouldn't be able to testify effectively unless there was closed circuit. On appeal, the First Department said that was enough. You did not have to find that the child would suffer some sort of severe or substantial mental or emotional harm in order to let her testify via closed circuit. Our respondents' actions toward the child were clearly intended for sexual gratification. They were not just innocent horseplay. What he did on 2 occasions was ask this 10-year-old to lock his bedroom door, to give him a massage, and then straddle him while he bounced her up and down near his penis and kissed her on the mouth. No innocent explanation for that behavior. It must have been for sexual gratification. He also told her, "Don't tell your mother." This behavior occurred in the presence of a younger child. Skyline AP, respondent, was legally responsible for this child, and the child gave out-of-court statements about abuse, and that was corroborated by the expert, what we sometimes call a validator. This expert was described in the First Department decision as a psychotherapist who specialized in child sexual abuse. There was an expert called on the other side, but his testimony was insufficient. And although the child was inconsistent in some minor details, that was not crucial, and the fact that there was no physical injury to the child was not crucial. Dylan R., a sex abuse adjudication out of Clinton County, a stepfather to 2 boys who also had 2 boys of his own. This one's tough here. The stepchildren were teenagers. They had previously been sexually abused by a relative. There were concerns that they were being sexually inappropriate with each other. They were interviewed, and they described that the stepfather had been forcing them to engage in sexual acts with each other and with him. The 2 stepchildren made out-of-court statements separately to 2 investigators that the stepfather had been forcing them to perform oral and anal sex on each other while he watched and while he coached them on how to perform the acts. They also disclosed that he'd forced the younger stepson to perform oral sex on him in the presence of the older stepson. The older stepson admitted that he had told people that he and his brother were having sex with each other, in effect voluntarily. But he said that he told people that because the stepfather badgered him in a meeting with the mother not to disclose that it was the stepfather. Both boys also said the stepfather showed them pornography. Stepfather did admit that he had shown the older boy pornography. So the boys' out-of-court statements cross-corroborated each other and were further corroborated at least by the admission that the respondent made that he showed the older boy pornography. Hadley C., I put it in here. It's a neglect finding. It should be a sex abuse finding, but I put it in here because the activity involved is sexual, and I think many other courts probably would have found sexual abuse. But it's kind of an interesting scenario. We've got 2 children in this case. The lower court dismissed the abuse but adjudicated neglect, but the Third Department reversed this to the older child, and here's why. The older child had been living with parental grandparents for over a year before the proceedings start. They were in California. So under the UCCJEA, New York State was not that child's home state, and the lower court really had no jurisdiction over her at all. Maybe something could happen in California, but it sounded like that child was safe in any event. As to the younger child, the appellate court said, yes, neglect. This child made out-of-court statements that the respondent touched her vaginal area with his hand, put his finger into her vaginal area, and touched her vaginal area with his clothed penis, and that this had happened multiple times while she was in bed with him. She had demonstrated the digital penetration to the psychologist who had performed the sex abuse evaluation. The psychologist who used the Ewell stepwise protocol, something the Third Department has acknowledged as an appropriate protocol before, testified that the child's account of the events was consistent with the accounts of known sexual abuse victims. So we've got the out-of-court statements of the child supported by an effective validator. This expert witness corroborated the child's out-of-court statements. It should not have been admitted as evidence, says the dad on appeal, because he says, well, I was only found to have neglected the child, and this is a person whose expertise is in sexual abuse. The court didn't find much about that, saying abuse is in effect a subset of the broader concept of neglect anyway. It didn't really make a whole lot of sense. Of course, as I mentioned, I think other courts may have found the matter to have been sexual abuse. Leslie R., 2 stepdaughters made out-of-court statements that the stepfather was inappropriately touching them. They were corroborated by the stepfather's admission that he was roughhousing with them. Although he did know that this was uncomfortable and that they didn't like it, he continued to touch them. The fact that he continued to touch them, even though they indicated he didn't like it, supports that his intent was actual sexual gratification. They didn't sustain any physical injury, but that's not necessary to prove. And the fact that one of the girls kind of vaguely recanted is not enough either. His own biological children, 3 of them, were in a lower bunk when he was sexually abusing one of the stepdaughters in an upper bunk. That's enough to show a real fundamental defect in his understanding of parental duties. Interestingly enough, one of the respondent's attorney had moved to subpoena one of the stepdaughters, and the attorney for the child moved to squash that subpoena, and the child's psychotherapist had provided a letter. The social worker had provided an affidavit that the child would suffer psychological harm if forced to testify, and the appellate court found that sufficient to quash the subpoena. Dayani, from the second department, father sexually abused his daughter. The child gave consistent, detailed, and explicit statements about what went on, corroborated by the testimony of a child sexual abuse expert and the father's written confession that he gave to the police. The child recanted, said it didn't happen, but the family court said that doesn't require, and the appellate division agreed, that doesn't require a determination that the child had not told the truth. Recanting is a common experience, and the expert had testified that this was false, that the child was probably pressured to recant after the father had been jailed. Daniel XX, a 15-year-old girl, testified in court that her stepfather had sexually abused her, forced her to kneel, took her shirt off, placed his penis between her breasts. 6 months later, he fondled her breasts. She recalled several incidents when she'd been quite a bit younger where he had taken off her pants or reached down her pants and touched her in her vaginal area. Mother testified for the stepfather and said that the child was just not consistent in these various claims, but the lower court said she was consistent and credible. And she didn't have to have any of her statements corroborated. She testified in open court. Respondent's counsel was given an opportunity to review the child's therapist's notes, given that the therapist used these notes to refresh. I'm sorry, I meant to say he was not given an opportunity to do that. But that was harmless error because the court only gave inconsequential weight to the therapist's testimony. Remember, the child had testified herself in open court. Apparently there had been sex tapes made by the mother and her husband, and the argument on appeal was that she should not have been allowed, the mother should not have been allowed to testify about that because it wasn't best evidence rule. I assume that the tapes were not available, I guess, but they said that that was the appellate division had no problem with that, and derivative findings were made regarding the younger children. A matter of X, 12-year-old child made out-of-court statements that a respondent had sexually abused her, and that this was corroborated by the respondent's admission in the child safety conference that ACS traditionally held. So ACS had a conference before the case was brought into court around the child's safety, and during that conference, the respondent admitted that he'd had sex with a 12-year-old. Obviously, that was used against him in court, and then on appeal, he argued that it was a violation of his rights to counsel, and the First Department said, you didn't get right to counsel until the matter went into court, and therefore, this was used against you. He also, by the way, excessively punished that child with a belt. All right, before I get into Article 10 dispositions and permanency hearings, I want to do 2 things. First, I want to read a second code for my attorneys who are watching either live or later on tape. Second code for CLE. This code is L for Larry, S for Sam, 1016, S for Sam, B for Bob, 2. So again, LS 1016 SB2. I also wanted to comment before I moved into the cases, very interesting cases on Article 10, dispose and permanency hearings. I wanted to make a comment about Phillips versus Orange County, the case that we've all been following and the aftermath of for quite some time now, involving particularly the question of being able to interview children at school without parental permission. We are very pleased, of course, that after the long decision coming out, being all over the internet, then an article published by school attorneys basically telling schools to just say no when CPS comes or get some kind of a court order, all kinds of things we couldn't do. We have a assistance now of a regulation. The regulation is 18 NYRR 432.3 little I subsection 2 little i's. Let me repeat that one again. 432.3 little I subsection 2 little i's. If you take a look at 432.3, it'll jump out at you, but very clearly indicating that schools must cooperate if CPS comes asking to interview the child, that they cannot demand information about what the allegations are. They may know, they might be the one who called in, but that they cannot demand information about the allegations. They cannot demand a court order. They cannot demand proof that the parents know about what's going on. None, none, none. They can only essentially ask for two things: the name of the caseworker, some identification of the caseworker, some identification of the child or the multiple children that need to be spoken to. Obviously, that would be so. And that, of course, schools have their own policy and procedures about whether someone is going to be present in the room as the child is talked to. That's an area we've all talked about a lot. In certain circumstances, having someone present from the school might be helpful if the child feels safe and comfortable with that person. In other instances, it might be harmful, and the caseworker might indicate to the school personnel that it might be preferable if they were not in the room. Maybe they could watch through a one-way mirror, for example. Or, of course, it may be important to tell school personnel that they will be witnesses to the court proceeding if, in fact, they are going to watch the interview. So the regulation has resolved the issue. The schools must allow entrance. That's the reg. I've even suggested if it's causing a problem that perhaps CPS workers should be walking around with a copy of the regulation. They certainly should be walking around with a phone number for their lawyer so that the lawyer could call a school lawyer if someone attempts to stop an interview. All right, so let's take a look at Article 10, dispositions and permanency hearings. Lots of interesting cases in here. We'll start with Alexandria MB. Under Social Services Law 384B7A, there still is a section that allows a family court judge to make a ruling that diligent efforts do not need to be provided towards reunification. And in this case, there had been a prior parental TPR. And therefore there were grounds. You know, the grounds we tend to look at for no reasonable efforts are severe abuse, but this was a prior TPR. It's mother's burden to stop that order that there be no reasonable efforts. And to do that, she has to show reasonable efforts would be in the child's best interest, they would not be contrary to the child's health and safety, and the efforts would likely result in reunification in the foreseeable future. The case law is very clear. That's the respondent's burden to prove that, not the other way around. And as of yet, I have yet to see a reported case, this would be since that law went into effect in 1999, I've yet to see a reported case in which a parent has been able to do that. If severe abuse or any other kind of reason for a no reasonable efforts towards reunification is requested, the court shall grant it unless these three defenses can be proven by the parent. Robert P., a mother had stipulated to a finding she neglected the children, misuse of prescription drugs. She consented to a dispo order. 3 months later, DSS is alleging that she's failing to complete substance abuse and that she's not visiting the children. She's found to be in violation. On appeal, she says, they never gave me a written order. Obviously, they hadn't gotten around to getting the order in writing. Appellate Division says you don't need a written order when there's proof that you were in the proceeding, you were in the court when it happened, you had a lawyer next to you, you stipulated to the conditions, you knew what they were, they're binding. Walter T.T. versus Chemung County. A father's incarcerated when the children go into foster care due to mother's neglect. When he's released, he petitions for modification of a prior visitation order. He'd like to see the children. The lower court says, okay, supervised visits twice a week. Well, that's pretty good, I think. But the father appeals and says, no, I should be given more than that. No, says the third department. Family court was proper. They determined that you had regularly missed visits in the past. You had been not a proper supervisor. You didn't properly discipline the children. In fact, your visits were chaotic. That you had a history of mental illness, no evidence of treatment, regular use of marijuana, even when you were caring for the children. Even though the attorney for the child argued that the father should have unsupervised visits, it was not in the child's best interest. I make the point, nothing in here indicates that he was ever made a respondent, and yet the court limited his access as a non-respondent parent to these children. Darren S. Mother credibly testified that the father repeatedly was violent to her and hit the child with an extension cord, punched the child in the face. Father had to complete a batterers program, anger management, parenting skills, and he could only have once a month supervised visitation. Apparently, he argued on appeal, I'm incarcerated in Rikers Island. Some of these programs aren't even available for me. And the appellate court said, well, even if they're not available while you're incarcerated, the agency can still supervise you, and they can continue to get an extension of that supervision until you can access the services at another prison upon your release. And the neglect finding collaterally stopped him from arguing in family court that there were about domestic violence on a family offense petition because he had a full and fair opportunity to litigate the issues. Nina C., father had neglected the children using excessive corporal punishment, domestic violence, and Queens County Family Court said no visits for father to the children until we get more information from the therapist. On appeal, the father, denied any wrongdoing. He was angry. He was hostile. So on appeal, they said, this is a sound and substantial basis to seek more information before you determine what's visitation. So, the court isn't delegating the visitation question to the therapist, which is improper, but is simply saying they want more information before we determine how much visitation to provide. Kaylee E., an award of Article 6 custody to 2 children with their relatives. The children were removed from their parents in 2007. The father was charged with and criminally convicted of raping, sodomizing, sexually assaulting 2 stepchildren. This had gone on for years. Some of that would have occurred when one of them would have been a preteen. He was convicted of that. He's in prison till 2032. In 2008, family court had issued an order of protection that would remain in effect until the children were 18, that the father have no contact. Let's be real clear. That's clearly an illegal order. Statute does not say that the court can issue an 18-year order of protection against a person who's a parent. But that's what happened. The children continued in the care of the parental relatives during the supervision of DSS. If that 18-year order of protection was in the custody order, the Article 6 custody order, it could be a doable. If it was in the Article 10 order, it can't be. In any event, in a permanency hearing, DSS and the caretaker sought a permanent order of custody where you could have issued an order like that, and the court was granted it. At that time, continued the order of no contact, which again implies to me that the order of no contact was under the 10. The third department denied his appeal on this issue of no contact. It said you didn't object when the court issued that order of protection in 2008, that you opposed the custody petition, but you didn't put in any evidence in. You didn't even ask for contact. You said you wanted the children to know you were alive and that you existed, and they know where you are, and they know why, and they're not expressing any desire to resume contact. And therefore, the answer really was you didn't preserve the issue of no contact, even though there was at least, I think, some question as to whether it was illegal to begin with. In putting it in the Article 6 custody order, that would be appropriate, and that would be a way to get 18-year order of protection. And we need to take a break at this time?
It's hard because there's really terrific information on all this case law, Margaret, but I am going to suggest we take another quick break right now. Please keep sending those questions and feedback in for Margaret. When we come back, she's going to continue her review of current case law trends, so we will be right back. Welcome back now, everyone. I will turn the program back over to Margaret in just a moment, but first, please do continue sending your questions and your feedback. If we do not have time to answer those today, Margaret will be following up with you if you have provided that contact information, an email address, phone number. Margaret, what is the next case for our discussion?
We're still talking about Article 10 dispositions and permanency hearings. We have the decision of DL and Delilah. I included this one, although it was a denial of mother's motion to increase visitation and was moot since she had then had her parental rights terminated by the time it was appealed. It was a good case to be aware of, in which the appellate court reminded us all that family court has no authority to order any contact after a contested TPR has resulted in a termination. Court of Appeals, Haley ZZ. Angelo VV, 2 children who went into care because mother was hospitalized for mental illness. Father, voluntary care. Father then is notified of the original placement proceedings. He's notified of the permanency hearing. He was not notified of the original placement. And he comes in and files a 1062 motion asking to terminate placement. The family court holds a lengthy permanency hearing and includes his motion and says, nope, we're keeping this children's goal return to parent and we'll provide for more visitation to the father. Father appeals and says, there's no grounds against me. The government should not be able to hold my children in care when there's no grounds against me. I have a superior right to custody over a non-parent. I'm not required to file for custody. I didn't place these children. Very interesting decisions. And I'm wondering if this is where things might go in the future, particularly cases regarding non-respondent parents. However, the Third Department found the question moot since by the time the case was up to be heard, I think a significant decision that would have come out of it, moot because the father had since obtained legal and primary physical custody of the children. Now 3 interesting cases actually from Clinton County. Dwayne FF, mother gives birth to a child while she's in jail, local jail. She's waiting to be transferred to state prison to start her 7-year sentence. DSS brings Article 10 positions because there isn't anyone to care for the child at all. Mother makes an admission. The court holds a permanency hearing along with the dispo. And at the hearing, DSS says, well, goal is reunification. And the court said, what, reunification? She's about to start a 7-year prison sentence. How's that going to work? And father is also in jail for a long prison sentence. And the court questions why saying return to parent makes any sense. The court then, sua sponte, changed the child's goal to adoption. Now, the child was only 3.5 months in placement at that point. So in order for adoption to happen, there would have either had to been a surrender, and apparently the parents weren't going to do that, or there'd have to be a TPR. So the court could make the goal adoption, but the agency was still going to have to engage in all diligent efforts to reunite, or there would be no way to TPR. Kind of awkward on some level. On appeal, the Third Department said, well, the lower court didn't err in changing the child's goal to adoption. Foster parents wanted to adopt, and the parents were going to be incarcerated, both of them, for many years. The appellate court said also it was appropriate that there was a denial of visitation for the mother. Again, kind of surprising, I think. The lower court apparently had said, rather flippantly really, that the child would receive zero benefit from visiting the mother, and therefore there was no point in it. The Third Department said, well, all right, the child is very young. The trip to mother's prison is a 12-hour round-trip ride, and therefore denial of visitation is really not improper. And that also denial of visitation for the infant to have sibling visits with a half-sibling was an error. There had not been an existing relationship, and there wasn't a specific visitation petition that had been filed. It was just part of the permanency hearing. Jasmine II, non-respondent father, is incarcerated. Mother neglects. The Clinton County caseworker finds the father in prison 250 miles away, lets him know that the Article 10 has been filed against the mother. He's been in prison for 3 years and hasn't seen the child. He's been there since the 6-year-old child was 3. So he's been there at least for 3 years of the child's life. He didn't have much contact with the child, although the caseworker allowed for some supervised contact. Dispo and permanency hearing is held regarding the mother, and the court is placing the child with a maternal grandfather and says no visits for the father in the court order. And that the only contact would be this supervised contact that the caseworker was doing. I assume that means some sort of phone call. The second permanency hearing, the lower court ruled that it was not going to limit contact with the father, but it was not going to establish visitation rights. While the first decision had been appealed, the appellate court finally ruled that the issue was moot because all the orders had been expired, but as the third department often does, it comments anyway, and says that the caseworker had told the father, you have rights to visits, and that he had not done anything to set up those rights, and that if it were to rule on the father's argument, they would say there was no merit. He hadn't requested visitation, and that prison visitation is not necessarily required with a parent. Justice H.H., again from Clinton County, father's child goes into foster care with the goal of return to parent. The lower court did not provide for visitation between the child in placement and a half-sibling who was a newborn son of the father. The appellate court said that's not error. These siblings have never had contact with each other. There's no relationship, and there's no actual sibling visitation petition. I don't know if some of these sibling rulings are going to be changed by the new sibling law that just got passed and that will be in effect by December, that you should take a look at if you're not familiar with it. Two appeals on the same case. Desiree F. This case has gone up to the appellate division multiple times. These are the two most recent times it's gone up. These are children who are in foster care with foster parents in Pennsylvania. They want to adopt them. There's a long history of the agency attempting to free these children for adoption that's been reversed on appeal before. And essentially, these are the next two cases, matter of Desiree with one site and then the next site. These are cases in which the court reviewed the permanency hearings, the third department in both cases making comments about the lack of the court having consulted with the children. The third department in the first appeal said that the permanency hearing order should be reversed. The lower court did not have a sound and substantial basis to change the permanency goal back to adoption. It was very critical of the permanency hearing record. It was meager, didn't reflect consultation with the children who would have been 8 and 10. The termination order at that point had been reversed, and the goal had been changed back to the parent, but there was not good evidence that the agency was really providing appropriate services. Caseworker didn't seem to know a lot about what services were even being provided, and there should not have been a change in goal. But there was a dissent to this. The dissent said, this judge has known about this family since 2007. I already know a lot about this family. Not having details on a permanency hearing when the court already knows about it doesn't seem all that bizarre to this dissent. And that, mother has serious problems, mental health issues, criminal record for sex with a child. She's a level 1 sex offender. She let the kids be around sex offenders. Yes, there have been some problems with the appeal, but some bizarre to the dissent that the goal should be changed. DSS had already filed to terminate again. In the second appeal, on the next permanency hearing, now the children are 10 and 12. Again, the court says you should have consulted with them. Again, they're still with foster parents in Pennsylvania. Mother's appeal, the permanency hearing, was moot, they said, because there's now been more orders. But again, the court said ongoing concerns. Yet again, this mother doesn't have a lawyer. It's not clear why she's being allowed to go pro se. Yet again, the family court should have an age-appropriate consultation. And this doesn't mean that the respondent has an absolute right to be present. That's an important site that you want to note. In other words, the third department is saying it does not mean that the respondent has an absolute right to be present when the children are spoken to at permanency hearings. Since we have a new law about children attending permanency hearings, that's a good case to keep in mind. However, here they said the court did speak to the children outside of the presence of the respondent without doing the proper balancing as to whether or not the impact of presence that the presence would have on the mental and emotional well-being of the child. Simply, the attorney for the child told the judge the children want to talk to you alone, and the judge did it without engaging in the balancing test. Therefore, without this balancing, it was improper to exclude the mother and improper to tell the children that anything they said to the court would be confidential. The TPRs are still pending regarding these children at the time of this second appeal. Brianna B., a mother's visitation with the children should be suspended. She's engaging in services, but she makes disparaging comments to the children. She's hostile in the therapy, and these things are adversely affecting the children. Eric X versus Carrie Y. Mother has sole custody of children when father is pleading guilty to assault and for hitting the 14-year-old in the presence of the 11-year-old. He's on probation, order protection that he stay away from the children for 7 months. While that is in place, an Article 10 is filed against the mother, and the children are placed with maternal grandparents in an Article 10 custody placement. Just after the father's order of protection ends, the lower court makes a finding that the children have been neglected by the mom, and the maternal grandparents are given ongoing Article 10 custody. Within 2 days of that, the non-respondent father appears and files an Article 6 petition saying he wants the children. The judge holds a hearing combining the permanency hearing as well as the Article 6 and dismisses the custody order. Remember, he's a non-respondent, even though it seems to me he could have possibly been made a respondent given his conviction for hitting the child in the face. But he's a non-respondent of this particular proceeding. And since the grandparents had Article 10 custody and were suitable resources, very interesting, the third department says they don't need to prove extraordinary circumstances as they would normally have to prove when a father is seeking Article 6 custody. He says there's been a change, my order of protection has ended, I want the children back. But the court says the children have been, with these maternal grandparents most of their lives. They have connections, particularly connections in school. He says it'll be fine. The court says he's minimizing the difficulty these children will have moving to his home. He says the children have behavioral problems because the grandparents don't know how to control them, although he doesn't tell us how he's going to do that. And father said the description, the event that led to his arrest and probation, he still describes that as getting a little physical with the child, which the court found minimized what he had done to the children. And when asked what he would do if things became difficult for the children, he said, well, I'll send them back to their grandparents. So, unable to prove it's in the best interest of the children for him to have Article 6 custody. I want you to think about what this means. Non-respondent parent asking for Article 6 custody of children, and the court saying no. Not any argument by the appellate division that because there was no pleading against the father that he was entitled to Article 6. Again, that issue is still out there. Denise J., very interesting decision from Westchester County Family Court. It anticipated the 1090A change regarding children appearing at permanency hearings. This is a 16-year-old young woman who's in a congregate care placement in New Hampshire. She has severe behavioral issues. DSS says, we don't want this child to come to her permanency hearing. Child is aggressive, dangerous, wouldn't be in her best interest. We'd have to transport her for hours. She'd have to be medicated, maybe even restrained. The attorney for the child says, I'm not substituting judgment. She knows what she's doing. She's asking to come. And the court says, yes, the statute does not give the court any authority to say no to a 14 or older child who wants to attend their permanency hearing. I did hear that Denise did come to the permanency hearing and that there was no significant incident. Demetria FF, out-of-state maternal uncle, wants to intervene in a proceeding regarding the children he is an uncle to, who are in care, and the lower court denied him a motion to intervene, saying, well, the case is resolved. The third department said, no, the case is not resolved. Your children are in care, and it's not resolved until the children are out of care. And under the statute, 1035F, he can intervene, and he should be able to intervene. I'm a little confused because I'm not really sure why he would have moved to intervene as opposed to simply filed an Article 6. Had he filed an Article 6, I think under current statute, clearly he would have had an opportunity to litigate his 6 within the permanency hearing. The court could have made a decision. I think the motion to intervene is not necessary. Keyshawn P., the respondent had severely abused 3 children. He was a person legally responsible, therefore derivative severe abuse on his bio child. He pled guilty to sexual conduct with one of the children he was responsible for, summary judgment motions regarding severe abuse and derivative, and then a 1039B order for no services. Second department agreed that the biological child was derivatively severely abused. That is the law now. Once ACS produced proof of the criminal convictions, then it's up to the respondent to show those 3 defenses. Remember, best interest of the child for reasonable efforts, not contrary to the health and safety, likely result in reunification. He couldn't show that. no efforts need to be offered. Let's take a look at termination of parental rights. A couple of general issues first. Micaiah saying you can't appeal a dispositional case if you did not appear and your attorney elected not to participate. In Joey J., it is not an effective assistance of defense counsel to advise mother that she should do better or could do better if she admitted the allegations in the termination of parental rights petition. In the Noah EP case, there was a summary judgment motion for termination on severe abuse grounds that was appropriate given the father had been convicted for murdering the child's mother and was imprisoned. In Antoinette LL, again, a summary judgment motion regarding termination, severe abuse of 3 children, repeated acts of sexual and physical abuse by the father. Lower court held a hearing and said it was in the child's best interest to be freed. The father appealed. 2 of the children were doing fine in their foster homes, wanted to adopt them. The oldest boy was in inpatient psychiatric ward. He had been horribly abused, anally raped by the father, forced to perform oral sex on the father. The child's therapist testified that the child had long told his therapist that he felt that he was safe and that he felt his family was safe because he thought his father was going to be in jail for the rest of his life. The therapist had to break the news to the child that the father was, in fact, no longer incarcerated, and that child really was going to benefit from the parental rights being terminated. In the abandonment TPR area, Alexandria MMB has a couple of good points to take a look at. In this particular case, there was an order that the mother have no contact with the child and no visitation, but that did not prevent her from sending gifts, money, or communicating with DSS, and therefore she was abandoning the child when she did not do that. DSS was not required to provide diligent efforts, but they didn't discourage it. And of course, a suspended judgment is not a permissible disposition in an abandonment. Jake W.E. sounds like a pretty rational, reasonable abandonment case. The child was conceived of a single sexual encounter. Father hears about it a year later. He fails to take any action to determine paternity, doesn't register, doesn't ask for DNA testing, doesn't visit, doesn't pay support. Termination, says the second department. But if you read the dissent, it comes out a little different. The dissent says, why is this being done? Termination is being filed. Father has offered his mother and his sister. He asked for a paternity test. When it was filed, he got an order of filiation. The mother's rights are not terminated. In fact, the child is being returned to the mother's care. So the dissent says, what is the point of terminating father's rights when the child is going to be placed with the mother? And on top of that, describes various reasons why the father has done fairly well lately and should have some contact. No legitimate purpose, says the dissent, for termination. Tanisha J., in order of protection that father couldn't contact the children, but that he was obligated to stay in contact with DSS. He was in jail, didn't make contact with DSS, abandonment. Colby II, 6 months before, the father actually did a few things. Visited twice, attended a child's permanency hearing, twice applied for custody, left a telephone message. The court said not enough, not sufficient contact, and made much about how DSS had tried to help this father, even though, of course, that need not be proven. Reasonable efforts need not be proven. Mental illness and mental retardation. Please remember, mental retardation termination is now described as intellectual disability. The case law for mental retardation continues and still applies. Brianna Monet, a mental retardation termination. The mother did have some skills. There was a bond with the children, but sadly she could not provide even basic care. Shemaya P., clear and convincing evidence that retardation resulted in mother's inability to care for her special needs children. Donovan Germain, mother's rights on mental illness grounds. Less than 2 years before the birth of this child, she had murdered her 3 other children by slitting the throat of the oldest child and then drowning all of them in the bathtub. She was not responsible for the murder based on her mental illness. For the last 8 years, she'd been in a forensic psychiatric center. She had persistent, severe schizoaffective disorder, antisocial personality disorder, obviously conceived a child in that environment. And those rights are terminated. Bruce P. and Chloe S., 2 children. There's just reported as 2 separate cases. Termination on mental illness grounds. Court-appointed examiner saying the mother has bipolar disorder, doesn't take her meds, no parenting skills, homeless. The report that contained a description of records that the expert had reviewed should not have been admitted. It was harmless error, however. Summer S.S., a termination of a Clinton County parent's rights to a child placed in care based on mental health issues. At the first permanency hearing, when the child would have been only in care about 10 months, the courts changed the goal to adoption and ended all visitation. DSS brings mental illness TPR as soon as the child's been in care in 1 year. The parents would not attend the court-ordered mental health eval, maybe on advice of counsel. It doesn't matter. This case reports, of course, that if the expert can base their opinion on prior records, it is okay. This expert had seen the parents years ago, was able to do that, and was able to demonstrate that the behavior that had continued to show the parents' inability to do what was right. For example, they joined a traveling carnival 2 months after this child was born and had been placed in care. The parents were still too mentally ill to take care of the child safely. Marie ZZ, rights were terminated on both permanent neglect and mental illness grounds. By the way, in the Fourth Department, that would not be permitted. The Fourth Department says one ground or the other, but not both. The Third Department apparently believes you can terminate on both grounds. She argued on appeal, I should have been given a guardian ad litem. The Third Department said you didn't ask for one, and on top of that, you were coherent in your testimony. It appeared as though you could certainly interact with your attorney. In the permanent neglect area, Raymond C.M., I just thought this was an interesting case in the context of the 384B7EI section that allows the agency to not have to prove diligent efforts if the mother failed to keep the agency apprised of her location, which this mother did. Endoran E.H., permanent neglect was not proven against the child's father. Diligent efforts were not made, said the lower court. The appellate court said no, diligent efforts were made. There was a service plan, but there was not sufficient proof that the father failed to plan. He had done plenty of things and been involved, and though he relapsed and used cocaine several times, he still was trying hard to plan for the children, and it cannot be said that he failed to plan. Jenna K., an incarcerated parent, still has to develop a reasonable plan for the children outside of living in foster care until they get out. The parent gets out of jail. This parent did not. Termination. Landon U., mother refused to take responsibility for a violent shaking of an older child that resulted in that child having severe cognitive delays. She participated in services, but she continued her denial and continued her involvement with inappropriate, unsafe men. Termination. Abdul-Bila, I think, Andre. In this case, the agency successfully proved diligent efforts to reunify did not be needed given the circumstances of the situation. Father had been criminally convicted of sexual abuse of a girl, sexual abuse of his 8-year-old daughter, and medical neglect of his severe special needs son. 384B of the Social Services Law still allows a court to make a ruling that there is a reason to not offer efforts towards reunification and excuse that part of the TPR, even though a 1039B motion might not have been made or even appropriate. Hezekiah L.J., father had pled guilty to murdering his 3-year-old daughter and assault in the second degree for what he did to his 17-month-old, who is the subject matter of this case. The court found severe abuse, excused the agency from making reasonable efforts to reunite with the surviving child, and then the lower court found severe abuse TPR. He appealed the court's order and said that his rights should be terminated, should not have been terminated on permanent neglect grounds. Why? I don't know. He was terminated on severe abuse grounds. Second Department disagreed with his arguments and affirmed the finding. Agency did not need to offer diligent efforts due to severe abuse, and therefore that prong of the permanent neglect did not have to be proven. Kind of a waste of time. Giovanni M., mother argued on appeal that the lower court had failed to suppress evidence that she said was illegally obtained. Very interesting decision that you might want to keep your hands on. The Second Department said application of an exclusionary rule to the observations of the mother's home would have detrimental impact on the fact-finding process and the state's interest in welfare of the children, and that outweighs the deterrent effect of applying the exclusionary rule. Not that we would tell our caseworkers to violate the rights of people, but apparently such evidence could be used. Morgan AHP, agency did not prove that it offered mother diligent efforts. The child had been in care with one foster care agency. They were on the verge of unsupervised visits. The child was moved to another agency, which immediately took a tactic of abandonment, of adoption, and the court found that very offensive. And even though the mother did not appear for the proceeding, the court still said there were not grounds to terminate parental rights. Nieva Karen B., the foster care agency, was not required to provide diligent efforts. Her rights had been terminated to 3 older children, and she didn't make the proof that we've described, the 3 defenses. I'd only point out, it's kind of sad to make that decision at the time of the TPR. Should have been done years or months earlier when the child first came into care, so that the caseworker didn't have to engage in services that weren't necessary. Aisha Tamika, in this particular case, the father failed to acknowledge the sexual abuse of an older daughter who was not the subject of the termination. He didn't complete a sex offender program, didn't meaningfully address his deviant sexual behavior, which was grounds to terminate his parental rights to this child. Alexandria D., mother failed to plan. She didn't focus on her mental health issues, her anger management problems, the child's special needs. Good language in here about her failures in visitation adding in. Gabriel BSP, a reversal of a termination of a non-respondent parent's rights to his 2 children. I urge caseworkers to take a look at this. You must be careful with a non-respondent parent. Just because there is no court order of services, you must provide services to a non-respondent parent, or there will be no grounds to terminate parental rights or no ability to assess if the child should be given to him. Good case to read in detail. Lawana M., a teen freed to be adopted. The caseworker tried to offer a father diligent efforts, sent him 25 letters and emails trying to encourage him to become involved. The father would act out in court. The child refused to visit the father. He's crazy. He's angry. The father denied that he needed services and said the teen should be forced to engage in family therapy. The child's therapist said it's harmful to force a child into therapy. Father was not making steps to correct conditions, and the child said, I would feel unsafe if I went home to the father. I want to be adopted. Tylene M.A., mother had completed a parenting course and remained in contact with the agency. She spoke to the children. Even when she was in jail, she would call the children on an almost daily basis and try to talk to them. The appellate court said this parent was a present parent. She hadn't completed the programs, but the caseworker couldn't even recall specifically what needed to be done, and the records that the caseworker used to refresh her recollection were not put into evidence. There simply wasn't enough proof that there was a prima facie case. Lehana A. is a Dale P. TPR, that is a termination of parental rights in a case involving an Article 10 custody placement. I thought that was worth keeping in your records. Joshua T.N., the Department of Social Services can engage in diligent efforts. At the same time, they can plan for the potential of the child being adopted. That's good practice. Nice job, Gary Lee, on that case to make sure that the appellate court acknowledges that that may well be done. It's really interesting if you just juxtapose that decision with some of the third department decisions saying they're confused why a goal would still be reunification while a TPR was pending or vice versa. This is what we're talking about here. In the TPR disposition area, Marcus B. This is a case involving the termination of a mother's rights after a suspended judgment. The mother had been removed from the child had been removed from the mother's care due to drug use. The child went home on a trial discharge. The caseworker makes an unannounced home visit and finds the father present in the home in violation of the court's order. He was only supposed to have scheduled and supervised visitation. 6 months later, DSS moves to terminate parental rights on the suspended judgment violation. And the court says no. The court says, look, your mother did violate, let this man in the house, but there's no evidence that he did anything wrong. And in the meantime, the mother had done everything that had been asked of her, and that the father being in the home was a lapse of judgment, but wasn't enough, and that the mother had a relapse in substance abuse after the TPR had been filed, but that was only admissible in the fact finding, not in the dispo. Of course, if he refiled the TPR, it could be admissible in the fact finding. And the court said no, the child should not have been freed for adoption, and the plan for the child was that that the child would be returned to the father. So here the appellate court says, okay, explain to us what the situation here is. You're violating mother's suspended judgment for allowing contact with the father, but your plan is to return the child to the father. So they're kind of troubled by that. It doesn't really make any sense. And why don't you just give the father Article 6 custody and stop with the TPR of the mother? Amari SGE, best interest of the child to be freed for adoption and to not be placed with a cousin and a maternal great aunt. 383 Subsection 3 of Social Services Law gives preference, of course, to foster parents to adopt when the child has been in their care for more than 12 months, and a non-parent relative has no preference over proposed adoptive parents selected by the agency. These children have been with their foster parents for years. Hazel O.O., mother violates terms of her suspended judgment. She didn't attend the psychotherapy. She did attend the psychotherapy, but she didn't participate in it or make any progress toward it. She wouldn't acknowledge the underlying problems that had resulted in the placement, basically allowing sexual offenders to have access to the children. And although she went to the counseling, a lot of the counseling session was taken up with her complaints about DSS, not with her making some progress. At the time of the appeal, however, the oldest child says, I don't want to be freed for adoption, and the youngest child says, I do. So the third department said the lower court should have made a clear record as to what the children wanted back at the time. Since both of them were over 14, we should have heard what they had to say. And now they said termination is in the best interest of the younger children, but as to the older child, it's moot. She's now 18. Ramel L.H., before the suspended judgment was over, the child was sent home and then came and returned to the mother's care under DSS supervision, with the suspended judgment continuing. DSS then brings a motion that the mother violated the suspended judgment and the court frees the child for adoption. On appeal, the mother says, hey, the child came home to me. That effectively ended the suspended judgment. The court says not under the statute and not under the comments the court made to you. You knew you still had to follow the terms of the suspended judgment. Nathaniel Micaiah A., preponderance of the evidence that mother violated her suspended judgment by not moving to New York State. Kind of interesting. Sounds like the suspended judgment had a court order that she had to move to New York State. She did not obtain suitable housing. She didn't have steady income. She didn't visit the child on a regular basis. Alicia M.S.L., the second department reversed a termination of both parents, reversed a termination. A permanent neglect was established, but they should have thought about some other disposition. Parents defaulted on the disposition, kind of interesting. We're going to give them something even though they didn't show up in court. Defaulted, and they failed to complete their service plans, but they'd made some efforts towards reunification and consistently visited. And then here's the real story. The child, who was 10, was strongly opposed to an adoption and wanted to continue the relationship with her parents, and there was no viable person who was seeking to adopt the child, and you know that's really what the case was about. Selena L., suspended judgment can be revoked when a preponderance of the evidence shows that the parents failed to comply with one or more conditions. This is a dispo hearing, so hearsay is admissible. The parents' attempt to comply with the conditions is not enough. They have to show progress, and that didn't happen. She went to programs, but she didn't gain insight. She didn't develop parenting skills. She didn't develop effective communication skills. The child's out-of-court statements about the father being allowed to have contact were admissible. Father was not supposed to have contact. Agency does not have to show diligent efforts during the period of suspended judgment. That was something that was demonstrated during the period of permanent neglect. Jade D.S.M.A.S. Timing on this is kind of odd, I think. A child has been in care for 15 months when maternal grandma now files for custody of the child. 15 months after maternal grandma files, a TPR is filed, and the lower court determines permanent neglect and then puts the custody petition with the dispo. If I'm reading this correctly, I could be not, but if I'm reading this correctly, it meant the court delayed doing anything with grandma grandma's custody petition for 15 months, which seems very inappropriate to me, and then combines it with the dispo, and then basically says, well, the children should be freed for adoption, child should be freed for adoption. They've been with the foster parents all this time. A grandparent doesn't have a right to custody superior over those people who've been chosen to adopt the child, but there hadn't even been a TPR, and there wasn't one for more than a year after the grandma filed. It's a little odd for me. She's been with these foster parents obviously forever. Grandma also claimed on appeal, I said that the child might be Indian, and there should have been some information about ICWA, and the appellate court said, no, you didn't provide enough information for anyone to think this was an ICWA case. Patricia I.H., again, I'm a little concerned about it. It says this child goes into non-kinship foster care within days of birth. 2 years later, which I'll admit is quite a while, maternal grandma files for custody and agency files a TPR against both parents. Okay, so permanent neglect, the custody and the dispo on the permanent neglect go together, and there's a ruling that the child should be freed for adoption, and grandma appeals. Second department says, no relative should have no precedence over adoptive parents selected by the agency. Child has been with foster parents since birth, now 9 years. So if I'm reading that correctly, he goes into care within days of his birth. 2 years later, maternal grandma files for custody, but her custody matter isn't heard for years and years when it's combined with the TPR. I'm not sure I'm understanding how that's working, but in both of these cases, the children apparently were very bonded to foster parents. All right, now let's take a look at unwed father's rights. Nina M. In this case, the court ruled that the man was not a notice father in regard to mother's termination and the child's subsequent adoption proceedings. He said, I am a notice father. I lived with the child's mother at the time of birth. And the statute does say notice father lives with the child's mother at the time of birth. However, it also says mother and the child. And here the child had been removed at the hospital at birth. So he might have been living with the mother when she was pregnant. He might have been living with the mother after she had the baby, but the child wasn't there. Kind of interesting. Blake I. Father's consent to a step-parent adoption, a private one, was not required. But I like the discussion of how it's supposed to be handled. Third department says, look, first you're supposed to decide if the unwed father is a consent father. And then if he is, you can decide whether he's abandoned. But if you don't have a decision that he's a consent father, you don't have to get to the abandonment issue because you don't need to terminate the rights of a man who's not a consent father. And they say here, this man was not a consent father. He provided no support for the child. He'd been in prison for most of the 2 years before this adoption. He is responsible, even though he's in prison, to support the child. And he offered no proof that he supported the child before the prison sentence, and he wasn't able to do that. He didn't offer proof that he wasn't able to provide some support while he was incarcerated. And the fact that there was no court order telling him he had to pay support is not an excuse. That's an issue that comes up a lot in these unwed fathers cases around the issue of support. Perhaps certainly is arguable that it may seem unfair to the parent, but it does not. I think you wouldn't want a case where the caseworker told the father, don't worry, you don't have to pay support. But the case law has said over and over again, nobody has to tell him he's responsible for paying support. If he doesn't pay, then it is a factor in determining that his consent is not needed. On Hal P., at the time that the child went into foster care at 8 months of age, a man had signed an acknowledgement of paternity in the unwed situation. His name then had been put on the child's birth certificate, and he was registered with the putative father registry. 3 years later, a respondent comes forward, another man comes forward, and tells the foster care agency, I'm really the biological father, and he files a paternity petition. That petition is dismissed. There's no motion to vacate the prior father's paternity finding. Foster care agency then files to terminate the rights of the mother and the original acknowledged father. And the respondent says, let me intervene in this termination. Family Court allowed him to intervene, ordered a DNA test, and he was in fact the child's biological father. Now he gets visits. The father now files for custody of the child. The mother surrenders her rights, and the court then holds a hearing to determine if this father is a consent father and to hear his custody petition. Second department concurs. This man's consent is not necessary. He's not been paying sums for child support. It's not in the child's best interest to be adopted It is in the child's best interest to be adopted by the kinship foster parents. There's no need to go any further. Basically, he's too late to the party. John J. versus Kayla I. Mother is married, but living apart from her husband, becomes pregnant by another man. Before the child is born, she and her husband are back together, and they're together when the baby is born. But the baby is placed in foster care at birth, derivative allegations against the mother and the husband. Within 6 weeks of the baby being born, the biological father files a paternity petition, and the respondent husband says, hey, equitable estoppel. I'm the one that took care of the mother during the pregnancy. I'm the one that's married to her. I'm the one that gets to claim legal parenthood. The court orders DNA testing. It is determined that this man is the biological father, and the court then just says there's no equitable estoppel here. Equitable estoppel is appropriate when the father, the person who's alleging equitable estoppel, can show that the child relies on that man as the father. Here they said, you know, it's not really the case. Yes, he supported the woman during pregnancy, but there's no reliance of the child on the representation that the father was the husband. The child was placed in foster care at birth, never lived with this husband, never saw the husband in the home as a father. It is true that there are visitation schedules and that he sees the father, this husband, at weekly supervised visits. It is true that he shows up with toys and clothing and some food, and that he's affectionate with the child, and that the child, who's now 2.5 years to resolve this case, now 2.5, calls the husband daddy, but there really isn't a whole lot of reliance on this man being the father, who really doesn't visit as often as he should. And the petitioner, who, remember, filed within 6 weeks of this child's birth, never acquiesced in letting this other man act like a father. He promptly brought a paternity petition. Therefore, the husband and the child are not in some sort of a parenting relationship that's recognized and operating. The child was removed right away. The lower court says petitioner should be adjudicated. Husband, you're out of luck. Obviously, that's going to impact what happens with the child in the foster care situation. Surrenders and adoption. Sierra L. This mom of 3 surrenders her children under the condition that she get a supervised visit each year and that DSS would provide the visits. The surrender occurs in the summer of 2006. The mother then says, DSS said to her, would you please forego the visits while we transition the children into the adoptive placement? And she agrees to do that. But in 2009, so that's 3 years after the surrender, she now starts saying, I want my yearly visits. And in 2014, when she still isn't getting her yearly visits, she now files in court. Family court says, dismissal. You're not even stating a cause of action. The third department reverses and remands, says there is a hearing. It says, look, this mother believes the children have been adopted, but nothing on the record from the lower court told us if, in fact, these children have been adopted. And we don't know, therefore, if we should apply Family Court Act 1055A, subsection B, the enforcement of surrender terms pre-adoption, or Domestic Relations Law 112B, the process for enforcement of surrender terms post-adoption. If the children have been adopted, then those conditions should have been included in the adoption order, and the mother should have gotten a copy of that. We have no record of that, so we don't know if the mother was given the proper paperwork, and the parties should appear in court within 45 days. Mother should be given the proper paperwork, and she should then be allowed to go forward with arguing that she's entitled to this visitation. Of course, the court did not determine whether she should get it, just saying you can't just get rid of her that easily. Stephen M., a lower court decision from Ulster County Family Court on a surrender. This was birth parents who signed a surrender with the condition that the child would be adopted by a particular person, and that if that person were unable to adopt, that DSS could find another adoptive family. Sure enough, the identified person indicated she no longer wished to adopt, and the family court ruled that this was a failure of a material condition, and that therefore the parents could vacate the surrender. So the question really was, this agreement that DSS could find another adopted family, did that mean that when that happened, she couldn't vacate the surrender? But the family court judge ruled that she could. But I think here's the real issue, the last line. The child was now over the age of 14 and wasn't going to consent to being adopted, and the goal had been changed to return to parent. Shaquana Michelle ML versus Leaky Watts. No longer in the child's best interest to continue contact in a visitation request after children had been adopted. So this was a case where there had been conditional surrender. Now the children were adopted. Mother was asking for visitation that she was being denied. And the first department said no. Mother's irrational, unstable, violent. She's hostile towards the adoptive parents. She doesn't get it that these children have in fact been freed for adoption and are now adopted. And she signed surrenders, and that's it. Naquan LG. A denial of a motion by a mother to vacate her judicial surrenders of her children. This is kind of interesting. The children are in kinship foster care since 2008. In 2010, a TPR is filed. In 2011, mother signs voluntary surrenders with counsel. 23 months later, so this, the beginning part moves pretty quickly. In care at 08, TPR filed in 10, 2011 surrender, but 23 months later, apparently the children are still not adopted. Because mother then files an order to show cause. She wants to vacate her surrenders. And she says, I want to vacate my surrenders because the surrender was not done properly. It said that I should be offered services and supportive counseling, and the court never did that. The second department says, look, 383C3B and 380C5C list the procedures that are appropriate for a judicial surrender, but it doesn't say anything about what should happen if the judge doesn't do it appropriately. And there's a presumption that the judge is going to do it appropriately. It says that if there's fraud, duress, coercion, that the surrender can be undone. But that's not what is being alleged here. The instruments that this mother signed in front of the judge said in bold capital letters that the surrenders were immediate, that they were final, that she couldn't cancel, she couldn't change, she couldn't get the children back. They were conditional surrenders, and this was the condition, that the mother would get contact with the children as mutually agreed upon by the parties. Well, we know what that means. That means totally in the hands of the adoptive parents. In the 2 years since signing the conditional surrender, problems were going on in the agreed upon visitation. And the mother filed to revoke her surrenders, talking about this lack of supportive counseling. Obviously, that was a bit of a legal dodge. She's mad because she's not getting the visitation that should happen. The court did not give her the notice about supportive counseling, but there's nothing in the law. So the appellate court says, sorry, you signed the surrenders, and there's nothing here that says we can reverse them just because the judge didn't tell you that. The dissent, I think, made the situation a little bit more clear. The dissent said, look, family court's colloquy when she surrendered, it was misleading. It was unfair. She should be allowed to vacate the surrenders. The judge said during the surrender process that there was a visitation agreement and talked about the mother's rights regarding visitation, and that the visitation was something she was in effect going to get. But really the visitation was upon mutual agreement, which means she would get no visits if the adoptive parent chose not to grant them. The dissent said, look, this is unfair. The mother probably focused in what the judge was saying, probably didn't really pay much attention to what was written on the paperwork. And if only fraud, duress, or coercion are allowed to revoke for a surrender to be vacated, then there's no remedy if the court does absolutely nothing to make sure that a parent is understanding what they're doing. Very interesting. Okay, in our last few minutes, just a couple miscellaneous cases. Gerald H.H. versus Carrion. Unfounded and indicated report. DSS offered only their case notes and no live witnesses at the fair hearing. The case notes said that a father had been found to have grabbed his 11-year-old by the neck, lifted him off the ground, yanked him out of bed by the arm, pushed him down the stairs, and that he stumbled. The caseworker had interviewed both the child and the child's therapist and had gotten this information. Also said that there had been some prior neglect of another child. But the caseworker and any of the witnesses that were involved in this were not called by DSS at the hearing, but just the notes were submitted. The father and his wife both came and testified this didn't happen. The father said, I would be incapable of lifting a 110-pound child out of a bed with one hand. The wife said, the kids told me that he lied about the neglect. The father and the child's mother were engaged in a bitter custody dispute where there had been numerous unfounded reports made between them. An indicator report can be retained if it's based on hearsay, but here the appellate division said this hearsay is seriously controverted, and DSS had meager evidentiary showing based only on notes, and the subject provided live testimony that the events had not occurred, and the appellate division unfounded the report. Gwen W. versus OCFS, here there was, in this Article 78 proceeding, a hearsay evidence that DSS submitted, significantly undermined by the mother's proof at this fair hearing. And the third department also, again, unfounded a CPS report. Here, we had a situation involving a child that was 2 years old. The 2-year-old had a broken leg. The agency brought an Article 10 proceeding against the mother, but later ACD'd that proceeding. Criminal charges were also brought against the mother that were later ACD'd. The mother's story was, while I'm attending the 2-year-old who needs her diaper change, the 4-year-old said, I have poopy on my hands. The mother then lets go of the 2-year-old, and she says, the child's feet were only 4, maybe 12 inches from the floor. I thought the child would sort of land on her bottom, but the child apparently landed somehow on her leg and whimpered. Thinking that there'd been a sprain, the mother applied ice, but then took the child to an urgent care center, and the child's right tibia is broken. Mother, while the Article 10 was brought, was kept out of the home for 3 months. So ACD'd, and now she seeks a fair hearing. Before I go any further, I will just comment that maybe an ACD should be combined with the waiver of a fair hearing. But there was not a waiver, so there was a fair hearing. DSS submitted notes of the interviews of the 4-year-old, the surgeons, the child's geneticist, not the caseworker, did not testify. The surgeon said the injury could not have occurred the way the mother described, and that more force would have been needed. There was a spiral fracture. Surgeon did not testify and did not know that the child had a genetic condition. The child's geneticist told the caseworker that the child had something called hemihypertrophy, I guess, probably pronouncing that wrong, which causes the left side to grow faster than the right side and leaves the child's bones on the right side more susceptible to pressure. This expert believed that even a drop of 2 inches could cause a weight shift, and that it didn't look like a spiral fracture to him, but it looked like a fracture going through the bone that might be because of this medical condition. Interestingly enough, the experts had never told the parents that the child was at increased susceptibility to bone fractures, but the geneticist gave all these notes to the caseworker, was not present for the fair hearing, could not testify, poor health. Also, the 4-year-old is the one who had said he saw mother throw the baby and that he demonstrated this with a doll. But the teacher was called to testify in the fair hearing, and the teacher of the 4-year-old said, look, I was there when the caseworker interviewed the child. And this caseworker should never have done the interview in the way the caseworker did, providing an affidavit that went into court and for the neglect proceeding, maybe part of the reason there was an ACD, and said that the worker pressed the 4-year-old, made suggestions to the 4-year-old about how the mother acted. And the teacher said the worker provoked the child to throw the doll in frustration, and that it was not really a depiction of what the child had seen. The teacher testified at the fair hearing and saying the 4-year-old would never have thrown the doll, but for the suggestive and insistent conduct of the caseworker. The mother also provided affidavits from the child's pediatrician. The child has never been abused or neglected. She got a report from a psychologist that said that the mother didn't have mental health problems or substance abuse issues, didn't have violent behavior, no impulse control. Appellate court ruled that the CPS report would be unfounded. It would be very interesting if the CPS report was unfounded while the ACD was in effect. Unfounding means the whole record has to be sealed, but yet there would be a court order requiring ongoing supervision of the parent. There's been proposed legislation to fix that little problem that's never passed. All right, in the last minute, I have one last case. I know some of you thought I wouldn't finish, but I am. Edick versus Gagnon. It's a private custody case, but the court awarded primary physical custody to the father. The mother, among other issues, argued that evidence regarding an unfounded CPS report should not have been admitted. The third department said that the underlying facts regarding the CPS investigation are admissible if relevant. I have difficulty with the decision. The CPS worker apparently testified about the underlying facts of this unfounded. I don't understand how you can interpret Family Court Act Section 651-A, which says an unfounded report or any portion thereof is not admissible in a custody case. What is the point of that statute if you can simply get around it by saying that the CPS worker can testify about the details of the unfounded investigation? Okay.
That was a lot of information, Margaret, and I wasn't sure you'd get through it, but you did. A lot of great information we are all out of time for today. We really do want to thank Margaret Burt for this terrific, comprehensive presentation on the legal issues affecting the CPS and child welfare work that you do every day. Thanks to everyone for participating in today's training. Please do remember to complete that participant reaction questionnaire before leaving. And for attorneys interested in obtaining CLE credit, make sure you sign the attorney roster, fill out that evaluation, and complete the attorney affirmation form with those CLE codes. We really do hope this program has highlighted the current legal issues affecting the work you do to keep children and families safe in their communities. We hope everyone has a great day. Thank you, Margaret.